and its challenges in the era of globalization. Also, we would like to express our sincere gratitude to the organizing committee for their amazing work in preparing for this event.
Before we begin, allow us to formally introduce ourselves. I am Randy, and this is my partner Nofa. We are here today as hosts, and we will be guiding you through the entire event. Before starting on today's events, we would like to read the rundown. The first is the opening. Second is the recitation of a holy verse of the Quran. Third, singing of the national anthem of Indonesia, Indonesia Raya, and followed by the Unisba hymn. Fourth is the reports from the chairman of the committee. Fifth is the remarks from the dean of the Faculty of Law, Unisba. Sixth, opening statement from the rector of Unisba. Seventh, traditional dance performance. Eighth is the international seminar. Ninth is the Q&A session. 10th is the providing of certificates, and finally 11th, and the final one, is the closing.
To begin this event, let us invoke the name of Allah by reciting the Basmalah together. Bismillahirrahmanirrahim. Following this, we will listen to a recitation of the Holy Quran by Dekia Selsa and the translations of the Holy Quran by Bella Aulia. We welcome them to the stage.
Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. أيها الذين آمنوا إذا قيل لكم تفسحوا في المجالس فافسحوا فافسحوا يفسح الله لكم وإذا قيل انشزوا فانشزوا يرفع الله الذين آمنوا منكم يرفع الله الذين آمنوا منكم والذين أوتوا العلم درجات والله بما تعملون خبير بسم الله الرحمن الرحيم يؤتي الحكمة من يشاء يؤتي الحكمة من يشاء ومن يؤت الحكمة فقد أوتي خيرا كثيرا وما يذكر إلا أولو الألباب صدق الله العظيم.
I seek refuge in Allah from the accursed Satan temptation. In the name of Allah, the most gracious, the most merciful. O believers, when you are told to make room in gatherings, then do so. Allah will make room for you in His grace, and if you are told to rise, then do so. Allah will elevate those of you who are faithful and raise those gifted with knowledge in rank. And Allah is all aware of what you do. In the name of Allah, the most gracious, the most merciful. He grants wisdom to whatever He wills, and whatever is granted wisdom is certainly blessed with a great privilege. But none will be mindful of this except people of reason. The great God is true. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to Dekia Selsa and Bella Aulia for their beautiful recitations of the Holy Quran. Hopefully, by reading the first, may this event be blessed by Allah subhanahu wa ta'ala. Amin. Next, we will sing the Indonesia national anthem, Indonesia Raya, followed by Unisba hymn. This session will be led by the conductor. Ladies and gentlemen, please stand up. Ladies and gentlemen, please be seated.
After this, we will hear a report from the chairman of the committee by Dr. Sri Ratna Suminar SHMH. We welcome her to the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable Director of Universitas Islam Bandung, Professor Dr. H. Edi Setiadi SHMH and his staff, the Dean of the Faculty of Law of Universitas Islam Bandung, Professor Dr. Hefik Yusdiansa SHMH and his staff, the management of the Universitas Islam Bandung Foundation, the professors within the Universitas Islam Bandung, the deans and heads of institutions within the Universitas Islam Bandung, the speakers, the distinguished guests, the seminar participants, and all the esteemed audience. First of all, let us express our gratitude to Allah Subhanahu wa Ta'ala, the most gracious, the most merciful, because with His permission today, we can gather here to join, participate in the international seminar organized by the Faculty of Law Universitas Islam Bandung, which is also in celebration of the 70th birthday of Professor Dr. Toto Tohir Suriaatmadja SHMH. Blessing and salutation are always offered to our beloved Prophet Muhammad Sallallahu Alaihi Wasallam, who has led us from the era of ignorance to a time of dignity and knowledge, and whose intercession we will always await on the day of judgment. The theme we arise in this international seminar is the influence of the legal system on the development of national civil and its challenges in the era of globalization. The seminar was conceived in response to the growing complexities of globalization and its profound influence on national legal system and civil development. And today's interconnected world, the legal framework of a nation is not only a reflection of its domestic policies, but also a critical interface with global standards and practices. This seminar sought to address key questions such as how national legal system adapt to the pressures of globalization, the role of law in fostering sustainable civil development, and the challenges of aligning national priorities with international obligations. By providing a platform for dialogue, this event aims to contribute meaningful insight and practical solutions to these pressing issues. In relation to the theme, we are presenting 5 speakers, namely Professor Dr. Toto Tohir Suriaatmadja SHMH from the Faculty of Law Universitas Islam Bandung, Professor Dr. Stefan Kos from the Universität der Bundeswehr München, Germany, Professor Dr. Nur Asyah Muhammad from the International Islamic University, Malaysia, Professor Madya Dr. Abdurrahman Chapakia from Fatoni University, Thailand, Dr. Siti Sarah binti Sulaiman from University Teknologi Mara, Malaysia, each of whom will present their material in front of all of us. This international seminar is conducted in a hybrid format with 311 online participants via Zoom and approximately 100 offline attendees. This international seminar can take place thanks to the assistance of various parties. Therefore, on this occasion, allow us to express our gratitude to the Rector Universitas Islam Bandung and his staff, and the Dean of the Faculty of Law Universitas Islam Bandung and his staff, as well as the sponsor who have participated in this seminar, namely Dr. Subandi SHMH as the head of the Legal and Public Relations Bureau of the Supreme Court of the Republic of Indonesia, and Dr. Undang Munggopal SHMH as the head of the Central Kalimantan High Prosecutor's Office, both of whom are alumni of the Faculty of Law at Universitas Islam Bandung, and other parties that we cannot mention by one. The highest appreciation is also extended to all the committee members who have worked hard for the success of this international seminar. We realize that the organization of this international seminar still has many shortcomings, both in the presentation of the event, administrative services, and limited facilities. For that reason, we sincerely apologize. In conclusion, may all the participants of the international seminar benefit greatly from this international seminar. That's all from me. Thank you very much for your attention. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to Dr. Sri Ratna Suminar SHMH for the comprehensive reports. Next, we will hear remarks from the Dean of the Faculty of Law Unisba by Professor Dr. Efik Yusdiansyah SHMH. We welcome him to the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah, alhamdulillahirabbil alamin. Wassalatu wassalamu ala asrofil anbiya'i wal mursalin wa ala alihi washabihi ajmain, amma ba'du. Honorable Chairman of Unisba Foundation, Honorable Rector of Universitas Islam Bandung, Professor Dr. Haji Edi Stadi SHMH, Honorable Vice Rector of Universitas Islam Bandung, Honorable Dean and Head of Institution within Unisba, Honorable Leader of Father University who have graciously joined us of this occasion, Honorable Professor Dr. Toto Tohir Suriaatmadja, a respected professor and inspiring legal figure and an extraordinary figure who has devoted himself for 42 years at the Universitas Islam Bandung. We also extend of gratitude to the esteemed speaker from various countries who have participated in this event, Professor Dr. Stefan Kos from the Universität der Bundeswehr München, Germany, Professor Tupuan Dr. Nur Asia Muhammad of the International Islamic University, Malaysia, Professor Madya Dr. Abdurrahman Chafakia from Patani University, Thailand, and Dr. Siti Sarah binti Sulaiman of University Teknologi Mara, Malaysia. We also acknowledge the fellow lecturer, student, and all attendees who contributed to the success to this event. Praise to Allah Subhanahu wa Ta'ala for His grace and guidance, enabling us to convene and this significant event. This international seminar is organized to commemorate the 78th anniversary Professor Dr. Toto Suriaatmadja SHMH, a distinguished scholar who has made substantial contribution to the advancement of legal science in Indonesia, particularly in the field on civil law. Professor Toto, with his dedication and devotion to civil law education, has prepared a generation that is ready to face the complexity of future civil problems. The theme we are exploring today, the influence of the legal system on the development of national civil law and its challenge in the era of globalization, is highly pertinent to the evolution of law, particularly civil law, in our current global context. As globalization becomes more intricate, the national legal system must adapt to the ongoing change and dynamic. The seminar aims to explore the impact of the legal system on the development of the civil law within a country, along with the challenge presented by globalization, engaging with legal experts from different countries with offer valuable insight, and is anticipated to help generate solutions for the legal issue we currently face. I am confident that this seminar will prove to be a valuable experience for all participants. Let us seize the opportunity to exchange knowledge, share experience, and explore innovative ideas. It is my hope that the outcome of this seminar will contribute positively to the advancement of legalization in Indonesia and globally. Finally, I would like to extend my gratitude to everyone who contributed to the organization of this event. May Allah Subhanahu wa Ta'ala constantly keep His grace and guidance upon us all. Thank you. Billahi taufiq hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Professor Dr. Efik Yusdiansyah, SH.MH, for the warm remarks.
Next, we will hear the opening statement from the Rector of Unisba by Professor Dr. Edi Setiadi, SH.MH. We welcome him to the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahilladzi arsala rasulahu bil huda wa dinil haq liyuzhirahu 'alad dini kullih walau karihal musyrikun. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh. Allahumma sholli ala Muhammad wa ala ali Muhammad amma ba'du. The Honorable Profesor Dr. Stefan Kus, the Universitas der Bundeswehr München, Jermani, yang berbahagia Profesor Topuan Dr. Nur Asyah Muhammad dari International Islamic University Malaysia, yang berbahagia Profesor Madya Dr. Abdurrahman Chapakia from Patoni University Thailand, dan yang berbahagia Dr. Siti Sarah binti Sulaiman from University Teknologi Mara, yang saya hormati Wakil Ketua Yayasan dan Sekretaris Yayasan, para dekan, serta para guru besar dan peserta seminar. Saya mengapresiasi acara seminar dalam rangka Purna Bakti seorang guru besar. Dan ini adalah, seingat saya, ini adalah tradisi pertama kali di Unisba. Sudah, kalau tidak salah, baru satu orang guru besar yang sudah pensiun, yaitu Profesor Kiai Abdurrahman. Dan ya, pensiun saja. Gitu ya. Jadi semestinya tradisi orasi ilmiah ketika pengangkatan guru besar dan orasi ilmiah ketika pidato perpisahan harus menjadi tradisi kita, karena ini adalah tradisi akademik. Dan ini di sini berkumpul para guru besar, dan mungkin paling cepat 5 tahun lagi saya yang akan berpidato perpisahan tahun 2029 kalau ada usia. Disusul oleh para guru besar yang berdiri di sini, yang duduk di sini. Jadi sekali lagi saya memberikan apresiasi kepada Fakultas Hukum yang telah mengadakan acara ini, acara ilmiah, dan ini adalah tradisi akademik, itu adalah tradisi Qur'ani, tradisi Islami. Jadi sebagai sebuah perguruan tinggi Islam sudah selayaknya kita bukan hal yang luar biasa mengadakan kegiatan-kegiatan akademik, karena itu adalah tradisi Islami, tradisi Qur'ani. Saya tidak perlu menguraikan tema seminar ini karena tadi dari mulai Ketua Panitia sampai Pak Dekan sudah mengungkapkan tema seminar ini. Singkat saja, ya, mohon tradisi ini diteruskan oleh fakultas yang ada di Unisba. Dan para guru besar juga, dan calon guru besar harus mempersiapkan diri untuk pidato perpisahan nanti. Baik, finally, I would like to thank to everyone who initiated and carried out this seminar, namely Faculty of Law and other parties who have helped. Thank you for all your attention and cooperation. To the participant, thank you for joining this seminar. In the name of Allah, the most gracious and the most merciful, I officially open this seminar. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Professor Dr. Edi Setiadi SHMH for the warm opening statement.
After this, we will show a dance performance. This special performance will be shown by our student activity unit Lingkung Sendi Budaya Sunda. Ladies and gentlemen, please enjoy the performance. thank you to the Lingkung Seni Budaya Sunda for their amazing performance. Hopefully, this performance can add excitement to today's event.
Now, let's move on to the most awaited event of the international seminar, the influence of the legal system on the development of national civil law and its challenges in the era of globalization. This seminar will be moderated by Mr. Rimba Supriyatna SHMH. We welcome him to the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asrofil anbiya wal mursalin wa ala alihi wa sahbihi ajmain. Amma ba'du. Good morning, everyone's here. Distinguished ladies and gentlemen, I welcome you with warm welcome to the University Islam Bandung. For today's seminar, I will take the role as the moderator, and we're gonna discuss about wonderful and excellent topics right now about the influence of the legal system on the development of national civil law and its challenge in the era of globalization. This is the topic which is very intriguing for us to learn how the national civil law system and the global trends will shaping and adapt the form of the law in various countries. Right now, we already invite several honorable speakers, which consists by various countries from Indonesia, from Malaysia, from Thailand. I have to introduce first. There is things that I have to explain about the discussion, and I hope everyone's here and everyone's who virtually attend this seminar will posing your question in discussion and Q&A session actively. So before we start our discussion, I will briefly introduce our honorable speakers. For the first speakers, this is our special person here, the Honorable Professor Dr. Haji Toto Tohir Suriaatmadja from Universitas Islam Bandung. Give him applause, please. And the second one, we have the Honorable Dr. Siti Sarah binti Sulaiman from University Teknologi Mara, Malaysia. Please be seated. And the rest or the remaining speakers are joined with us virtually using the Zoom meetings application, which is the third one, the Honorable Professor Dr. Nur Asia Muhammad from the International Islamic University, Malaysia. Professor Dr. Nur Asia Muhammad, can you hear me?
Yes, thank you very much. Alhamdulillah, the sound is clear.
The voice still cannot hear in here.
Or okay, actually, on my part, I think the sound is okay, and
Okay.
hopefully that the technician can check on the.
It's already solved. The problem is already solved. We can hear you clearly here.
Oh,
Thank
okay.
you.
Thank you very much. Alhamdulillah. Okay.
Alhamdulillah. Okay, the next speaker is the Honorable Professor Madya, Dr. Abdullah Rahman Chapakia from Fatoni University, Thailand. Prof. Abdullah Rahman, can you hear my voice here?
Alhamdulillah, alhamdulillah.
Okay, thank you. It's very clear. And last but not least, we have the Honorable Professor Dr. Stefan Kuss from Universitas der Bundeswehr, München, Germany. Prof. Kuss, can you hear me? Okay, while we're waiting the technician to solve the problem, I will continue the fruitful and the interesting discussion on this event. So this is a privilege to have all the speakers here. Hopefully we can begin the discussion to take topics very timeless and very emerging issue, so we can learn about the development of the legal system, especially for national civil law on various states or nations. Okay, before we move to the first session, the speaker will be allocated 25 minutes on its presentations. And after all the presentators have finished their presentations, we are gonna open the session for discussion and Q&A. After that, only 3 from participants here that allowed or permitted to posing the questions. 1 from or 2 from the inside Aula Utama Unisba, and 1, maybe the last one, on the Zoom meeting. So only 3 questions will be accommodated on this discussion. Maybe we have a look first to the allocation time left. If the time is still remains, we will maybe adding more question on it. So without further ado, let's dive to the core of this seminar. I will give the first chance for Prof. Toto to presentate the insightful material to us. So without any further, the place and the stage is yours, Prof. Toto, please.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah wassalatu wassalamu ala rasulillah wa ala alihi wa sahbihi wa mawalah. Saudara-saudara kalian, ini jadi pertama saya ingin mengucapkan terima kasih ya kepada fakultas. Saya tidak sadar bahwa ini adalah acara untuk menghormati saya, gitu kan. Saya lupa ya bahwa saya itu sudah umur 17 tahun gitu kan. Saya lupa ya. Perasaan masih remaja. Nah, terima kasih Pak Dekan. Ya, saya tidak tahu dari mana biayanya, pokoknya yang jelas ada acara ini gitu kan. Mudah-mudahan tidak dipotong THR dosen nanti ya. You know THR? Oke, ya. Saya salah sangka. Jadi pertama saya diminta bikin makalah ini, ya. Kedua ternyata saya juga harus bikin makalah untuk nanti siang. Ya, jadi saya bikin 2 makalah dalam sebulan kurang karena kemarin kan saya harus ya umroh. Jadi mungkin tidak sempurna makalah-makalah ini, ya. Tapi saya coba kemukakan, ya. Dan saya tulis dalam bahasa Indonesia, saya presentasikan dalam bahasa Indonesia. Mudah-mudahan bisa dimengerti dengan bahasa Indonesia ini ya. Saya ambil judulnya itu pengaruh sama dengan judul seminar. Jadi pengaruh Anglo-Saxon terhadap ya hukum perdata Indonesia. Jadi sempit ya, disempitkan terhadap hukum perdata Indonesia. Next ya. Jadi Indonesia itu ya dijajah oleh Belanda. Ya, dijajah oleh Belanda. Jadi colonialism by Dutch ya, kemudian the legal system of Dutch ya, or the legal of Dutch ya, is include of civil law system ya, atau dalam bahasa oh berdiri aja, masih kuat kakinya enggak ya? Ya, jadi independence ya, bring to change of politik economy ya, but in law ya, Indonesia ya still Dutch system ya, the special character of civil law ya, is law made by parliament ya, not by judge. This is the primary character ya. Tuh. Jadi ciri utama dari hukum Eropa kontinental, sistem hukum Eropa kontinental itu adalah hukum dibuat oleh parlemen, bukan oleh pengadilan. Ini ciri utamanya, ya. Tapi tentu ada karakter-karakter lain yang kita akan coba lihat, ya, pengaruhnya, ya, influence to Indonesia, ya, sistem. Oke, next. Ya, ini interaksi antar bangsa itu kan intens ya. Jadi interaction ya interstate is very intense ya. Bahasa Indonesia saja lah ya, biar cepat lah ya. Soalnya harus sambil terjemahkan seorang hese gitu kan. Bisa sih, hanya rada lama gitu. Prof ngerti Prof? Ngerti ya? Saya kan produk tahun 40 Prof. Jadi bahasa Belanda saya bisanya. Kalau bahasa Inggris tidak bisa. Nanti kalau ada yang tanya bahasa Belanda, bahasa Inggris bisanya, bahasa Belanda tidak bisa gitu kan. Ya. Oke, nah persentuhan ya, persentuhan Pak Sep, persentuhan jadi aula mastumun nisa ya. Persentuhan dan saling mempengaruhi antar negara semakin kuat, terutama setelah berlakunya GATT dan WTO ya, GATT dan WTO. Hal ini tambah dengan lahirnya pola komunikasi. Pola komunikasi kita itu kan sekarang tidak lagi kayak dulu ya. Kalau ngobrol harus ketemu, kalau sekarang malah kita ngobrol dengan orang yang tidak tahu siapa dia. Ya, who is, ya, who is-nya itu dia tahu gitu, sekarang ini. Ya, jadi kita hanya ngobrol saja, diskusi gitu. Nah, dengan tempat terjadi suatu peristiwa, selain itu ya, internet itu berubah, tidak lagi lokal tapi dunia ya, tidak lagi berbicara negara tapi borderless. Ya, kita bisa bicara dengan orang mana saja, ya, jam berapa saja. Kalau dulu kan saya waktu kecil, begitu habis sholat isya sepi dunia ini, ya. Tidak ada apa-apa lagi. Makanya dulu banyak anak orang tua kita itu, nah, karena tidak nonton TV. Kalau kita kan sekarang banyak kegiatan, ya. Kadang-kadang sampai jam 1, jam 2 ya, karena banyak itu. Tapi kemudian sholat subuh kesiangan, ya. Nah, karena apa hubungan itu ya, interconnection, ya. Interstate, interperson, ya, kemudian interinstitution, itu bagaimana ada tidak pengaruh hukum Anglo, ya, Anglo-Saxon terhadap hukum Indonesia ya. Oke, lanjut ya. Berapa menit? 10 menit. Oh, 25. 10, oke. Next. Udah? Nah, ini hukum sektoralnya gini ya. Jadi civil law itu, civil law system itu based on codification ya. Jadi karakter utama ya, ciri khasnya itu codification ya. Dalam bidang tertentu, salah satunya hukum perdata dilakukan oleh kodifikasi. Belanda saat ini sudah menyatukan hukum dagang dengan hukum BW. Jadi buat booknya itu, NBW-nya itu mengandung, jadi tebalnya kira-kira 2 kali ini ya, 2 kali dus ini. Nah, twice this box ya, twice this box itu. Tebalnya itu, KUH perdatanya itu, new-nya itu. Ya, tebal sekali. Itu ada dalam versi Inggrisnya ada ya, jadi bisa kita baca. Tentu kalau yang bisa bahasa Belanda lebih bagus ya. Nah, jadi mereka konsisten dengan kodifikasi. Nah, pada saat Orde Baru Indonesia juga masih Repelita menunjuk kodifikasi ya. Tapi untuk saat ini kodifikasi tidak lagi menjadi politik pembangunan hukum. Mengembangkan pola hukum perdatanya lebih pada sektoral ya, berupa undang-undang atau peraturan perundang-undangan tiap sektor. Sehingga kalau dulu kita ada undang-undang baru itu jarang ya. Saya lihat gambar saya di sana agak kaget juga ya. Rambutnya udah putih itu. Nah, tapi bajunya ini sama semua. Sekelas inilah keadilan ya, sama. Menyimpang sedikit. Nah, Indonesia ini mengembangkan hukum perdata lebih pada sektoral berupa undang-undang atau peraturan perundang-undang. Jadi kita belum perdata ya. Kalau pidana udah berhasil dua-duanya, acaranya dari itunya. Banyak materi hukum atau dalam BW ya dan WPK ya, diperbaharui melalui undang-undang sektoral. Nah, oleh karena itu saya dengan Dr. Ujang Chandra ya menulis buku ini, Transformasi Hukum Perdata dari Kodifikasi ke Sektoral. Itu tahun berapa ya? Tahun 2014 atau 2015 gitu, udah lama ya. Jadi hukum sektoral ya, jadi dari kodifikasi ke sektoral. Terus ya. Yang tadi belum selesai berarti ya. Nah, sistem sektoral ini dianut oleh common law, oleh Anglo-Saxon. Kenapa Anglo-Saxon begitu? Karena memang bukan parlemen yang membuat undang-undang, hakim, judgment law itu, ya. Jadi undang-undang itu pelengkap. Nah, nanti ada ahli hukum dari yang bersistem Anglo-Saxon ya, bisa lebih terangkan. Anek-anek itu memang dimaksudkan untuk pelengkap. Kalau di Anglo-Saxon utama, ya, anek itu utama. Jadi, kok dibalik-balik saya? Anek itu pelengkap ya. Jadi melengkapi putusan. Itu kalau di Indonesia kan terbalik ya. Jadi mereka undang-undang itu memang melengkapi supaya lebih cepat. Kalau kita tidak, karena pikiran kita ini kan abstrak ya. Anutannya abstrak. Abstrak kemudian menjangkau masa depan yang jauh. Makanya sampai sekarang BW masih bisa digunakan ya. Nah, itu yang kedua adalah undang-undang catutan. Saya tidak tahu bahasa Indonesianya. I don't know of what is the Indonesian omnibus law. I use undang-undang catutan. No qualification, no compilation. Ya, undang-undang catutan. Ini istilah saya aja Pak. Belum diperdebatkan ya. Jadi sekarang Indonesia sudah punya undang-undang nomor 623 ya, pengganti undang-undang nomor 2 tahun 2 tentang Cipta Kerja. Ini isinya lebih dari 30 undang-undang. Di dalamnya itu lebih dari 30 undang-undang. Kalau ada yang rajin silakan menghitung lagi, lebihnya berapa saya tidak tahu. Tapi intinya adalah dari caplok sana, caplok sini, ya caplok itu sepanjang menyangkut materi yang menjadi judul undang-undang itu. Makanya saya istilahkan undang-undang statutan, Omnibus Law ini. Ya. Jadi ada dari undang-undang perumahan, ada dari undang-undang agraria, ada undang-undang dari perkawinan, nggak tahu ada tidak ya, asuransi, macam-macam itu. Ya. Nah diambil, disesuaikan dengan kebutuhan materi dari undang-undang itu. Ya. Nah ini bukan model kita, ya, bukan model Indonesia, tapi itu model Amerika. Ya, di Amerika sudah banyak undang-undang Omnibus Law ini. Ya. Makanya Amerika agak cepat membuat undang-undang karena memang modelnya banyak begini Omnibus Law. Ya. Nah, tapi Indonesia kemudian menggunakan. Nah, oke. Ketiga, terus Pak, next ya. Nah ini gugatan kelompok perwakilan class action representative action ya lawsuit. Jadi menurut HIR ya, menggugat itu adalah hak individual, the individual rights ya of citizen ya. Kemudian syaratnya kering Pak, saya sakit jadi kering. Punten ya. Kalau Indonesia biasanya maaf ya. Makanya bahasa Inggrisnya I'm sorry. Padahal salah naon maaf gitu kan. Oke ya. Nah, yang penting adalah punya hubungan hukum langsung terhadap objek sengketa. Jadi tidak mungkin seseorang menggugat kalau dia tidak mempunyai hubungan langsung dengan objek yang disengketakan. Ya, direct relation with gugatan ya. Nah, Ibu dan Bapak sekalian, kemudian berkembang gugat kelompok ya. Kelompok seperti dalam hukum lingkungan dan hukum perlindungan konsumen. Dan ini asli tidak dikenal dalam hukum Indonesia. Ya, dalam hukum Indonesia. Ada si HIR mengatur juga tentang kumulasi ya, tapi berbeda dengan gugat kelompok. Model gugatan demikian merupakan tradisi Anglo-Saxon ya, dianut di Kanada. Pertamanya dari tiling ya, dari tiling, pencemaran tiling itu yang dari Kanada mencemari sampai ke Amerika. Nah itu kemudian diajukanlah gugatan ya. Kelompok gitu, karena sangat banyak kan sepanjang sungai itu kasus pertamanya ya. Kemudian dianutlah ini, tetapi ada negara Quebec City yang dia tidak menggunakan Anglo-Saxon tapi menggunakan Eropa kontinental ya, dia tidak mau menggunakan gugat action ini, class action ini ya. Dia tidak mau padahal dia termasuk negara Anglo-Saxon ya. Jadi Indonesia itu hebat, cepat sekali menerimanya. Ya. Kemudian yang selanjutnya, ya. Nah karir hakim di negara Anglo-Saxon, hakim merupakan puncak karir dari seorang ahli hukum. Jadi di sana itu bukan daftar jadi hakim, tapi tunjukkanlah prestasi Anda, tunjukkanlah reputasi Anda, nanti Anda bisa diangkat jadi hakim. Di Inggris dan di Amerika itu kan. Nah, nanti kalau soal di negara ASEAN, di Malaysia atau di Brunei mungkin ada perbedaan juga ya. Ia dapat menjadi hakim kalau memiliki reputasi baik dan gemilang. Jadi hakim tidak dimulai dari nol. Sementara di Indonesia itu dari nol karir ya. Jadi hakim merayap dan tidak ya, dari tidak pegang palu sampai karir tertinggi hakim agung. Nah sekarang berkembang pengangkatan hakim non karir. Ya. Jadi ada tradisi dari Anglo-Saxon yang diambil ke dalam hukum Indonesia. Sehingga banyak sekarang yang menjadi hakim bukan orang pengadilan yang dari nol, bukan. Ya. Nah hanya di Indonesia sayangnya hakim non karir ini belum berbasis reputasi ahli hukum yang baik dan cemerlang di bidang hukum. Ya. Kita malah tidak tahu siapa sih yang diangkat sekarang menjadi hakim agung. Nah, harusnya hakim agung itu orang yang di bidang hukum terkenal di Indonesia, bagus hasilnya, bagus kerjanya, ya kemudian secara pribadi, secara akhlaknya bagus. Nah itu. Kalau sekarang kan kita tidak tahu. Ya. Berbeda dengan di Amerika sampai sekarang kan begitu ya. Nah ini agak beda. Jadi ini sayangnya syarat itunya, syarat berkelasnya tidak diterapkan dengan ketat ya. Oke, kalau tidak selesai ini. Tantangannya itu ya kita kalau mau begitu berarti kita harus mengubah politik hukum, kemudian juga harus mempercepat peraturan perundang-undangan untuk mengejar sektor-sektor itu ya. Oke, next. Jadi ini ya. Class action dan adanya hakim non karir di bidang peradilan, tantangannya adalah tindakan kecepatan dalam pengaturan hal-hal baru yang tidak termasuk dalam prolegnas, padahal sangat dibutuhkan dalam lalu lintas transaksi hukum di bidang hukum perdata tentu ya. Kemudian sebagai saran, selain perlunya mewadahi perkembangan yang ada, dapat juga disebutkan bahwa mengantisipasi pengaruh dari hukum lain perlu dibarengi dengan upaya penyesuaian dengan kebutuhan faktual masyarakat Indonesia. Sebab faktual kadang-kadang tidak sama dengan politik hukum ya. Itu saja dari saya, mudah-mudahan nanti berkembang dalam diskusi. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Hatur nuhun, Pak. Thank you for your enlightening presentation. This is set up the stage to be the very insightful material that you have been presented to us. And for the second, next we have the privilege to hearing from Dr. Siti Sarah binti Sulaiman, distinguished scholar from University Teknologi Mara, UITM Malaysia. So without further ado, Dr. Sarah, the stage and time is yours.
Saya berdiri ya. Thank you Mr. Moderator. Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Respected Rector, Deputy Rector, all professors, Dean, Faculty of Law, Deputy Dean, Ibu Ratna, thank you for the invitation. To all docents of Unisba, students and staff, speakers online, and also participants online. Thank you very much for the invitation. So inshallah, I try to share the overview from Malaysian perspective. However, my focus is more to land law, planning law, and environmental law. So hopefully the example of how common law affect the development of law in Malaysia can be seen in a very clear perspective. So my topic of discussion is uncovering the legacy of common law in shaping Malaysia's land use planning framework. Next. Okay, I think we all know kita kan serumpun, so Malaysia juga pernah dijajah oleh Belanda, British. So part of the historical development of land law include the law from Dutch law, English law, and also Islamic law. However, the Islamic law remain until now because there are certain part of property, okay, hibah, inheritance, faraid, wakaf, okay, still use the Islamic law. But our focus is on the civil law, on the land law aspect, okay. So the introduction of English law in Malaysia was a gradual process that began with British colonial expansions and resulted in a lasting impact on the country's legal system. Okay? And English legal principles shaped the development of Malaysia legal framework. And even after independence, Malaysia retained many aspects of English law which continue to influence the legal system today. Next. Okay, as part of British colonization, English common law principles were introduced in the Strait Settlement, Malacca, Penang, and Singapore by history. So these are the three states which first received the residence system, and later to the Federated Malay State, Negeri-Negeri Bersekutu, which consists of Selangor, Pahang, Perak, and Negeri Sembilan. And these are four states which the Sultan agreed to receive the residents. So due to that, okay, the residents bring in the English law and any law which suit the circumstances of the people in Tanah Melayu, Malaysia. Okay? And they do not touch, the agreement was that they cannot touch matters of individual matters, which is Islamic law. Okay? But as regard to contract, land matters, okay, we accept the English law. Okay, common law is based on judicial precedents, okay, decision made by judges, okay, in past cases from the basis of future rulings, and it is accepted, okay, until now, okay, the judgment. Next. Okay, so I think I have to relate to the specific area of law. So I choose land law and planning law to see how common law shape the judgment and development of land law in Malaysia. Okay, so a bit introduction of land law in Malaysia. Okay, so first we in Tanah Melayu we implement Malay customary land tenure. Okay, so the discussion can be seen in Malacca period. Okay, with the colonization of Portuguese, Dutch, and we also have Malay. So the first land law was Malay customary land tenure. Then there is a mixture of Dutch law, Portuguese law, and then we apply the torrent system. The torrent system is from Australia, so there's a lot of mixture of law that was implemented previously. Okay, so the first torrent legislation in the Malay state was Selangor Registration of Title Regulation of 1891, followed by Perak, Pahang, and Negeri Sembilan. Okay, and next. Okay, then later the system was introduced in Federated Malay State during English occupation, and it was first introduced in Selangor by W.E. Maxwell, who was then the British resident for Selangor. And the basic concept of torrent system is a system of registration. So what we have now in Malaysia is a geran, okay, as evidence that you are the owner of land. So torrent system is registration system. That is a conclusive evidence which shows that you are the owner of land. Okay, that is codification of land law. Okay, so every single aspect, okay, of procedures, okay, registrations of dealings like transfer, okay, charge, need to be registered. So all that rules and regulation is codified in the National Land Code. Next. Okay. So by having National Land Code, okay, because you can see the developments of the law. Okay, so until January 1966, we have one codification of all regulation pertaining to land matters. This is codified in the National Land Code 1965. So the Malay customary land tenures give way, and part of Islamic law, as I mentioned, remain, okay? So now we refer to only one code, okay? Like Prof. Toto mentioned, a thick book, okay, thick code. So similar like in Malaysia, NLC is also a thick book which contain provisions of land matters, okay? Next. Okay, although we have codifications of all rulings, procedures, provisions relating to land in one thick codifications, okay, but we do refer to judgment in court. Okay, there are certain matters that are not clearly mentioned in the provisions, which need some insight from the court. Okay, so I give you an example. In section 5 of NLC, there is a definitions of land. Okay, so the code gives the definition what is land. So why we need to know what is land? Because when you want to buy property, okay, do you buy the land only, the soil only, or you buy the property, the house, together with the land? So there is an argument, okay, that need to be determined. When you buy property, are you buying the land only, the soil, or together with the structure? And in the structure, if there is a fixture or chattel or item attached to the building, will that be considered as part of land? So the NLC does not define clearly which one is fixture, which one is chattel. Section 5 only explain what is land, okay? The surface of the earth, the vegetation, next. And all things attached to the earth or permanently fastened to anything attached to the earth, whether on or below the surface. Okay, so D give a problem. Okay, in the aspect of transfer, in the aspect of renting a house, okay, or selling a house in Malaysia, sometimes there is an argument. Okay, what form part of the house? Okay, if you rent a house, okay, you bring in all the furniture, television attached to the wall, kitchen cabinet attached to the wall. So when the rent come to an end, you have to leave the house. So can you bring all the items that you attach to the floor walls? Okay, because it as if has form part of the building. So accordingly, it's form part of property. Okay, so that's why the law, okay, need to provide clear guidelines how to determine whether the item is fixture or chattel. So we have law of fixture and chattel, but where do we refer the guideline? It is not stated in the NLC, in the code, but we do refer to the case law. Okay, to determine whether a particular item form part of land or not, we need to look at whether such item is a fixture or chattel. Next. And since NLC the code does not provide the guidelines to determine, therefore, the application of English law of fixture in Malaysia is decided in the case of Goh Chong Hin and Consolidated Malay Rubber 1924 case. A very old case, but the element subsists remain until today to determine what is fixture and what is chattel. So in this case, Prof. J said that I have no doubt that we are to apply in this country the ordinary English law of fixtures. So although torrent system comes from Australia, that one cater registration part, this one cater about law of fixture and chattel. So we do rely on judgment in court, okay? Even though we have thick codifications of land matters in the NLC, there are certain situations where judgment from judge is still relevant. Next. And the case that we refer to is Holland-Hodgson, the first case which laid down the two tests to determine whether the item is fixture or chattel. So the two tests are degree of annexation test and purpose of or object of annexation test. So these two tests remain until today, 2024. So the judgment first given in 1872. Okay. Next. Okay, second sample is from the planning law perspective. Okay, planning law is a tool to regulate and control development activities. Okay, whenever there is a new development activities, okay, the developer has to apply for planning permission from the local authority. This is the practice in Malaysia. Okay, and the local authority has right to determine condition, syarat-syarat, in order to ensure that the development is a sustainable development. Okay, so both of us in Malaysia and Indonesia, we are now having rapid development. I came to Bandung by using whoosh, whoosh, yes, okay. So along the track, I can see agricultural activities, okay, industrial activities. So the track that they use to build the whoosh train, okay, is land belong to someone, okay. So they take, acquire the land. Perhaps there is compensation paid, yeah. But that part is for the development. Same like Malaysia, we need more highway because there's so many cars, okay, traffic congestion. When there's traffic congestion, more highway is built. And new cars come in, BYD, Tesla, more highway is needed. So now they are using the outer road, meaning the forests are affected, okay? So this need to be controlled. So the function is on the responsibility of local authority. So under planning law, the control is by way of planning application, planning permission given if the developer can fulfill the proper plan of development, planning condition, syarat-syaratnya. If you want to build a track for whoosh, you must make sure that contribution is given to the people surrounding the area. Or public participation. When they want to build whoosh track, people or villagers around the track need to be consulted first. What would be the issue kalau ada track whoosh di situ? That is part of planning. And lastly, if the villagers refuse to give consent for the development, they can appeal. So we have planning appeal. So these are the law governing development activities, and the legislation referred to is Town, Country and Planning Act 1976. So we have a codification, another ACTA, another act. Okay. Next. So even though we have Act, Town Country Planning Act 1976, there are certain situations where court is consulted, okay, when there is another argument, okay. For example, under land law, the law provides for category of land use, okay. The land A is under agricultural land, land B industrial land, land C is for building. So your activity must be in line with the category of land use to control the usage of land, okay. And under planning law, they apply zoning. Ini zoning commercial, ini zoning education. This can be considered zoning education. There's Unisba, there's Unicom. So patutnya dijaga supaya tidak ada entertainment, so that the students will be like kept intact and focused. That is the idea of planning, okay? So, when there is a problem between conflict of category of land use and zoning, dia bertindih, clashes, zoning and category clash. That issue will be referred to court. Walaupun sudah ada akta, okay, but judgment of courts is still relevant, okay? Okay, now example that provision that we have is section 22(2) of the Town, Country and Planning Act, which require the developer to apply for planning permission, and the local authority will give conditions, okay, if it thinks fit, okay, to impose or refuse to grant planning permission. So the local authority will approve the planning application, but they will impose condition, syarat. That is way to control development. Okay, next. Okay, that condition to be imposed must be fit and reasonable. As we know, when local authority has power, bila ada kuasa, there is risk of misuse of power. So developer is a big company. So if you want planning permissions, you should do this and this and this. But that cannot be done, okay? There is control of power on part of local authority. So only reasonable condition, fit condition can be imposed on the developer to ensure equality and justice. So how to determine fit? Macam mana nak tahu what is fit conditions? Okay, because the Act does not provide the clear definition of what is fit. So we refer to the court in the case of Associated Provincial Picture Houses Limited and Wednesbury Corporation, or known as Wednesbury case. So the test to determine whether the conditions are fit or reasonable or not is to use the Wednesbury test resulted from the court judgment. Next. Okay, so by virtue of Wednesbury case, okay, Malaysia adopt the test, okay, in the case of Pengarah Tanah dan Galian Wilayah Persekutuan and Sri Lempah Enterprises, okay, 1979 case. So these are the list of conditions that need to determine, you need to fulfill this checklist to determine whether the condition is fair and reasonable or not. So these are resulted from judgment of court. And the first case to discuss about this is in English case. Next. So these are the tasks. Next. Okay, now the question that we want to highlight is, will the common law continue to thrive in an increasingly statutory environment? We are in a stage where everything must be codified. There must be law on climate change. Malaysia does not have law on climate change, but Indonesia has. So we're looking high on Indonesia, so the best practices, okay? So kami masih lagi berdiskusi, masih lagi arguing in parliament, okay, about the Climate Change Act, but Indonesia has already implemented it. So in this current world, everything must refer to an act, a codified law, because to ensure clear definition, clear results of the implementation, okay? So you can answer yourself, okay, what will be the future of the common law system? Okay, we can discuss the future, the past, okay, or the development of the common law, okay? But we cannot say that common law should be left behind. As you see the example of cases, judgment that we referred to, it remains until today. So common law principle is still relevant, but it must be worked hand in hand with the provisions codified, okay? Codified provisions. Next. Okay, as I said, statutes and legislation are increasingly supplementing case law in many areas, okay? The future of common law may involve greater integration with and reliance on statutes, leading to a more hybrid legal system that combines the flexibility of case law with the certainty of statutory law. Flexibility comes from the judgment of judge, but we need something which is certain to fall back to, okay? Kena ada, that's why we have development of research, okay? In a situation where there is no law, where there is issue and problem, where there is lacuna in the law, okay? So something needs to be done, but common law still remain as a reference. Next. So codification of law, okay, is still is important. While common law remains flexible, there may be a push toward the codification of certain areas of law, especially in complex and rapidly evolving fields like corporate governance or AI, technology law. Now, Malaysia also does not have law governing AI, but this is something which rapidly expanded, Okay, about ChatGPT, I do not know here, but our students in law faculty in UiTM, ChatGPT is their like their warrior. Okay, so something need to regulate that. The environmental law, which forever important, and also data protection. Okay, so codification will make laws more accessible and clear, and reduce reliance on judicial interpretation. Okay. Why we need a little bit more? Why we need to have a clear codification? Because sometimes judges, not all judges are well versed in certain area. I'm biased here. I'm talking about environmental law. So in Malaysia, judges need to be guided on what is the important aspect of environmental law, planning law, because that is technical part. The core part of law is their area of expertise. But the more technical part on planning, on environmental aspect, climate change, so we need to give guidance to the judges in order for them to understand and have a feeling when making judgment. Okay? So that's why there should be a balance between having codification of law and reliance on judicial interpretation. Okay, next. Okay, Alhamdulillah. We come to the end of it. I think I really hope I have shared and fulfilled the theme of the seminar. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you for your presentation, Dr. Siti. It's very fruitful and insightful for us, especially when we talk about the land law and comparing between Malaysia and Indonesia, which is using the foundational legal system is pretty different. So I mean, it's maybe intriguing for us to know more and compare with the legal system it's valid and occurs in Malaysia. I think it'd be adding our perspective, especially for the agrarian law between Indonesia and Malaysia. Okay, give her applause once again, the audience. So we move to the third speaker. Right now have joining us in the Zoom meeting, Professor, we are honored to hear from Professor Madya Dr. Abdul Rahman Chapakia of Fatoni University, or, sorry, I'm missing the one. Now the turn is from Professor Nur Asiah, the stage. Or you can hear me?
Yes, I can
Dr.
hear
Nur
you
Asiah?
loud and
Okay.
clear.
Okay, now it's your turn. If you have already, you can start the presentation.
All right. Thank you very much, Bapak Rimba Supriyatna, the moderator for this session. Director, Professor Dr. H. Edi Setiadi, the Dean of the Law Faculty, Professor Dr. Afiq Yusdiansyah, the Head of Departments, the professors, and all the respected participants for today's session. Alhamdulillah, I think first of all, I would like to thank the organizing committee for having me here in this international seminar on law. And I think time is a bit jealous, but we will try to achieve the objective of this seminar. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Allahumma salli ala Sayyidina Muhammad wa ala ali Muhammad. Ladies and gentlemen, Dr. Siti Sarah has started with the presentation about the background to the Malaysian legal system and the influence of the common law on the codification of the civil law. And I think it's a good start because when I look at the topic of the theme or the theme of the conference, the two things that came to my mind, okay? So whether I want to speak about the influence of the codification of law, the civil law in that context towards the legal development or the development of the legal system in the country. Or we will look at the civil law in the context of non-Sharia law, which I think since you have listened to the presentation by Dr. Siti Sarah addressing the first one in detail with a good explanation or examples from the perspective of land law and also the land use and planning law in Malaysia. So perhaps I will be focusing on the context of to what extent the codification or to what extent the Malaysian common law has been influenced by the common law in England, and also how the common law in Malaysia has rightly put the proper place or give the proper place to the background, the unique background of the Malaysian with differences of cultures, multiracial, with multi-religions. Okay, so this is perhaps the aspect that I'm going to look at in my presentation. And for your information, I have actually sent the recorded video. This actually has been converted into the video where, of course, it will take some time for you to download. It's with the committee. So for those who are interested to listen to my slide, I think you may get a copy of the video from the committee, because last night it was actually in the morning almost, where I was thinking about the connection or the Wi-Fi connection, whether it is stable or not, and a bit worried about the weather. Lately we have heavy rain in Malaysia, in Kuala Lumpur. So and last night I have decided to record, so at least if I may not be able to appear online, then at least you have a backup of my video. All right, so going back to my presentation, okay, so the gist of my presentation will be about what type of common law that we want to have in Malaysia. Okay, so perhaps I can mix the language. Okay, jadi apakah bentuk common law yang kita nak lihat mendepani undang-undang ataupun sistem hukum di Malaysia? Okay, bagaimana kita ingin...
I'm sorry, Prof. Asia, I have to interrupt you. Would you mind please to show the presentation on the Zoom?
Okay.
Because we cannot see the presentation yet.
All right, so I
Sorry
thought
to
that you
interrupt
have
you,
you have the slide.
Yeah.
Okay, let me share the presentation. Okay. All right, so can you see my presentation?
Yes,
Can you see
we
my
already
slide?
see the presentation. Thank you.
All right, okay. Because I have actually sent the copy of my slide to the committee, so I thought that the committee will do on my behalf. But it's okay, I am comfortable presenting and while talking. Okay, so if the gist of my presentation is basically on bagaimanakah kita ingin membentuk, mencerna the Malaysian common law, okay, berdasarkan kepada kepelbagaian Okay, various background of the Malaysian. Okay, we have different cultures, different religion, multiracial. So how are we going to develop it in order to achieve and to do justice to the parties, to all the people? Okay, so these are basically the outline of my presentation, as I mentioned, but of course it will fall back to the gist of the discussion that I've mentioned just now. So Dr. Sarah has rightly put and beautifully presented on the background of the Malaysian legal system. Okay, so we have started basically in the 12th century, where we had the evidence of the coming of Islam to the Nusantara, to Malaysia, to the Malay states in particular, and of course with the influence of the colonial, they have brought other races, other people to be part of Malaysia, and of course these people, we bring with them their own religion, their own cultures. So these are the background that actually forming the life of the people in Malaysia. So when we talk about Malaysian common law, we want to see what type of common law that we want to have in Malaysia. So in my presentation, I will be only focusing on the two things. Basically, the first one is on the position of Islam, and the second one is on the influence of the English principles, English common law, and the principles of equity, which actually been clearly stated in the Civil Law Act. Right. So this is basically the focus of my presentation. Okay. So I think we know that when we say Malaysian common law or common law, we always refer to law that are acceptable by the general members of the society, taking into account the needs of the local circumstances, taking into account also the local history, the religions, the cultural practices, values, as well as the aspiration of the people. And as this is what I mentioned, we have the unique background of the Malaysian, where in our law, okay, in our federal constitution, Islam has been mentioned clearly as the religion of the federation, meaning to say Malaysia is a country with a religion. Okay, so we know that there are other countries in the world which also declare Christian as the religion of their federation. But in Malaysia, we declare Islam as the religion of the federation. And if we look at the federal constitution, in addition to Article 3, which has the declaration, we have also Article 37, which emphasize about the roles, the duties of the king to protect Islam. And we have also Article 160, which declare that the Islam is the source of law, custom is the source of law, and English law can also be applied as part of the law. Okay, so this is what we're going to look at. So how far this law has developed, and or are we acceptable to that? Okay, or is it there are a lot of challenges in implementing this law or accepting this law as part of the law. So how the Malaysian common law is developed? Okay, so basically we will look at the three methods through legal recognition, where it has been incorporated in statutes, and then it has been accepted through court decisions, and it has been recognized by having the principle as part of the policy of the country, or and it is also accepted through the acceptance by the people, through the consensus practices of the people, and also it has been accepted through formal and informal education, or the process of legal literacy. And what are the initiatives that we have in order to develop Malaysian common law? Okay, so since I've mentioned earlier, the aspect that I look at more on Islam itself. So we have seen where the law has been amended under Article 1211A, where the court has the law has clearly stated that the law that is applicable to the Muslim is Islam, and the Sharia court is empowered, okay, we be at the same level with the civil court as far as Islam and the Muslim matters are concerned. And in other words, the jurisdiction of the Sharia court has been clearly emphasized through the legal process. Okay, and following that, the word court, okay, the word Sharia court has been incorporated in the definition of the court itself. Okay, for example, in the National Land Code, previously when we say court, it only refers to the civil court. So by having more product of Islamic finance product as part of the instrument offered by the bank, so it is important to have a clear law to see that when there is a conflict involving Muslim and the Islamic product, Islamic finance product, therefore it has to be referred to the Sharia court, meaning to say it will be heard by the expert in the field. Okay, and if we look at through education, the Malaysian common law has been developed through proper syllabus. In fact, I believe that the establishment of International Islamic University with the integration of Sharia and civil law is also part of the process of having or developing Malaysian common law. And we also focus in our seminars, discussion about harmonizing the law, harmonizing the civil law or any procedural which is not in Sharia compliant. Okay, and it is also important to ensure that we have qualified trained judges. Okay, because in the past, why we still have a lot of legacy of English law, because after Merdeka, even though we gained the independence, but the judges, most of the judges are either English judges or English trained judges. So a lot of initiatives have been done to prepare those graduated from abroad. When they come back, they have training, they have courses in which they can improve, polish their understanding of the local law, and especially for those who want to practice in Sharia court. So they have to undergo an extra courses in order to make them familiar with the Sharia court system. And there are a lot of special committee established in order to harmonize the civil and the Sharia law. Okay, and as far as the National Land Code, we have seen a lot of improvement, even though a National Land Code itself is more about procedures, but an obvious un-Islamic process that we have those days. I still remember when I teach my student in the 90s, we have the provision, if any of the parties breach the contract, therefore they have to be fined, okay, failure which they have to pay at 8% of the interest rate. So it's so obvious. So with the initiative of to harmonize the law, then now we don't have provision for interest. We have extend the meaning of court to also include Sharia court. And with regard to native court, I think with regard to the rights of the native, we have also established native court and also special court to address certain special issues. All right. these are the sources when we talk about Islam and the English equitable principle, for example, or English common law. So the two sources that are important is the Federal Constitution and also the Civil Law Act. And of course, in the land code, since we have referred to the land code, we also have some provision, okay, the saving clause under section 4 that allow for the states, for example, to have their own laws related to custom or Islam. Okay, in Malaysia, for state having wakaf enactment, for example, so they can refer to that codification of law. So that forms the basis for the law, the foundation for the law. But in some states without proper codification of the law, then of course they have to rely on fatwa. So that could be one of the example that I can share. Okay, so I have to move because time is running. Okay, so after having mentioned that, okay, we have the law that provide for Islam, but at the same time we have the law that still allow for imputation of the English principles, English common law, and principles of equity. So how are we going to develop? How are we going to color, to mold our Malaysian common law in the country? Of course, there will be some a lot of challenges actually. Okay, in fact, by having the codification of law, but still in many cases, for example, in under our law, even though registration is made as a very important element of the land law concept in Malaysia, but in order to do justice, in many cases, the court has also recognized the unregistered rights or interests over land. So to a certain extent, of course, it perhaps undermine the principle of the National Land Code itself, where registration is very important. But in order to do justice, the court always want to invoke the principles of equity. So this is always the challenge and remain a challenge in development of the Malaysian common law. Right. So because the interpretation of Malaysian common law rely so much on the concept of equity, the concept of natural justice, so this is all going back to the interpretation of the judges. But again, at the same time, we want the judges to exercise their judicial activism. It is very important. So next question is, what would be the basis for the judges, for the policymakers, for the legislators to rely on? Okay, so going back to the Federal Constitution, the first basis, of course, Islam. Okay, so the first basis, of course, Islam. So when the Civil Law Act allow us to refer to the concept when there is lacuna in the law, then we can refer to the equity. What would be the basis for the equity? So, of course, the guideline for the application of equity as a Muslim, as a country in which Islam is the religion of the country, of course, we should go back to Islam. So the call for having the Malaysian common law has actually been advocated by many top people in the legal fraternity. For example, the late Professor Ahmad Ibrahim and also the Chief Justice of Malaysia, they have advocated for the call for the Malaysian common law, and they have also called for the amendment of Section 3 and 5 of the Civil Law Act, which still give room for the imposition of the English common law of equity. And they suggested that if there is any uncertainty, if there is any lacuna, if there is any gap, the basis to fill in the gap first should be the religion and the culture of the people, right? So in fact, if we look at the Tun Ahmad Farus, the former CJ, he said that being an independent country, our reference to English common law and the rules of equity was politically indefensible. He continued that Section 3 needed to be either repealed or amended. Tun Hamid Omar, also former CJ, earlier than Tun Fairuz, he said that we should not defend Section 3 and we should always call for judicial activism. And Hashim Yupsani, one of the judges, suggested that Section 3(1) itself allow for modification of the law, but it does not really happen. Why it does not really happen? So this is the issue. Okay, are we so ignorant, or are we so inferior? We do not want to apply Sharia, and of course for non-Muslim brothers, they have the worry, they have the concern that the Sharia law will be made applicable to them. So there is a need for more outreach to these people to explain that the application of Islam as the law of the nation will not be to impose them to the non-Muslim. Okay, so it is on us actually. So moving forward, of course, we propose that the lacuna in any law, if there is any lacuna in any law, therefore reference first should be made to the local practices, to our custom, to our religion, before we look at the English common law, because Section 3 even see that subject to the needs of the local circumstances. The challenge is our judges, our lawyers sometimes do not understand what are the needs, or even if they understand, but they do not want to recognize, let's say, for example, Islam or the local practices as part of the law. Okay, so civil court must also recognize the fatwa, because that's how the Sharia law developed. Okay, so if the civil court refused to recognize fatwa, then there would be an obstacle to mold the Malaysian common law based on the needs of the people. Okay, and Sharia must prevail for the Muslim. Okay, so when there is a conflict, then of course Sharia must prevail. If you look at in the case of wakaf, it has been always considered as part of trust. When it is considered as part of trust, then the civil laws will be made applicable. If it is civil law, then of course it will go to the Sharia civil court instead of Sharia court. So of course we can imagine what would be the decision. So that's how in Malaysia practicing family wakaf is very restrictive because of the legacy of the English law, which does not recognize charity for your family. All right, and Suluh is one of the available dispute resolution which should be used widely. Okay, maybe in the form of mediation, but of course we should recognize Suluh rather than we go to court as the main source of way to resolve dispute. So I think with that I end my presentation. So welcome discussion on this issue. Thank you very much. Assalamualaikum warahmatullahi ta'ala wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Yes, thank you. Thank you for Professor Asia for your comprehensive and holistic presentation. It gives us very insightful to expand our knowledge. According to your presentation, there is influence of the legal system in Malaysia. There is some part of Islamic perspective and the customary law influence and respond to the globalization. Without further ado, we should move to the next speaker. Already join us in Zoom meeting, Professor Dr. Abdurrahman Chapakia of Fatoni University of Thailand. Prof. Abdurrahman, Can you hear my voice?
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. If you are ready, the times and the stage is yours. You can start the presentation, please.
Yes. Assalamualaikum warahmatullahi wabarakatuh. Innal hamdalillah nahmaduhu wa nasta'inuhu wa nastahdi wa nastaghfiruhu wa natubu ilayhi wa na'udzu billahi min syururi anfusina wa min sayyiati a'malina may yahdihillahu fala mudilla lahu wa may yudlilhu fala hadiya lahu. Wa asyhadu an la ilaha illallah wahdahu la syarika lahu wa asyhadu anna Muhammadan abduhu wa rasuluh. Allahumma salli wa sallim wa barik ala nabiyyina wa habibina Mustafa Muhammad wa ala alihi wa ashabihi wa man tabi'ahum bi ihsanin ila yaumiddin amma ba'd. Yang berbahagia Dr. Universitas Islam Bandung, Profesor Dr. H.E.D. Setiadi, SH, MH. Yang berbahagia Dekan Fakultas Hukum Universitas Islam Bandung, Profesor Dr. Ifik Yusdian Shah, SH, MH. Yang berbahagia Ketua Pelaksanaan, Ketua Pelaksana, iaitu Dr. Sri Ratana Suminat, SH, MH. Yang berbahagia Moderator Rimba Sufiatna, SH, MH, dan juga ahli-ahli panitia dari Indonesia dan Malaysia, pensyarah dan pegawai, juga mahasiswa yang saya kasihi sekalian. Alhamdulillah, saya akhukum fillah, Profesor Madya Dr. Abdul Rahman Capakia dari Fakultas Islam dan Undang-Undang Universitas Patani, Selatan Thailand. InsyaAllah pada hari ini saya akan bicara dengan bahasa Melayu. InsyaAllah bahasa Melayu boleh jadi campur sedikit dengan Melayu Thailand lah, Melayu Petani. Jadi judul yang saya akan bentang pada pagi ini itu berkaitan dengan pengaruh undang-undang Islam terhadap pembangunan undang-undang sivil negara di selatan Thailand, di wilayah selatan Thailand. Jadi 4 wilayah di selatan Thailand. Kajian ini mengkaji pengaruh undang-undang Islam terhadap perkembangan undang-undang sivil wilayah di selatan Thailand yang majoritinya itu penduduk di selatan Thailand ini majoritinya beragama Islam. Kemudian kalau kita tinjau kepada wilayah selatan Thailand, khususnya wilayah Fatani, Jala dan juga Narathiwat, dan satu lagi Stone, mempunyai keunikan budaya, struktur sosial dan sistem perundangan dapati berikut, iaitu pengaruh Islam. Penduduk di kawasan ini adalah Muslim. Kebanyakan Muslim, 80%. Yang mematuhi ajaran Islam dalam kehidupan sehariannya, termasuk dalam urusan perundangan. Dan juga yang kedua itu sistem perundangan sivil itu di Thailand. Mereka mengamalkan sistem perundangan sivil yang berasaskan undang-undang barat. Diadaptasi daripada kod-kod undang-undang seperti kod sivil Prancis dan juga Belanda. Cabaran unik kalau kita lihat kepada wilayah selatan Thailand, dia menunjukkan cabaran unik kerana perbezaan dalam latar belakang agama dan juga budaya dan masyarakat. Sebab di Thailand ni pada umumnya mereka memeluk agama Buddha, itu menyembah berhala. 94% yang memeluk agama Buddha. Hanya seluruh Thailand ni 6% atau 5% lebih yang memeluk agama Islam. Hanya yang majoritinya di selatan Thailand, tapi sebagai minoritinya di seluruh negeri Thailand. Dan juga di sana pengecualian pelaksanaan undang-undang. Jadi kalau kita tengok lihat kepada pengecualian pelaksanaan bab 5, iaitu berkaitan dengan keluarga, dan bab 6 itu berkaitan dengan warisan, pusaka. Dalam kod sivil negara di kawasan ini, bahasa selatan Thailand ini, di mana sistem perundangan Islam diterapkan oleh mahkamah syar'i, dia panggil Datuk Qadi Syar'i. Kerana dilantik oleh kerajaan Thailand, Datuk Qadi Syar'i. Di wilayah selatan Thailand ini terdapat penggunaan Datuk Qadi Syar'i, iaitu mahkamah keadilan tempatan menurut prinsip syariah Islam. Ia akan mempertimbangkan kes-kes berkaitan dengan keluarga dan juga pusaka warisan menurut prinsip-prinsip Islam. Jadi di sana itu kerajaan buat perhatikan di negeri Narathiwat ada 2 orang qadi syar'i. Di Fatani, wilayah Fatani itu ada 2 orang qadi syar'i. Dan di Stor tu ada, wilayah Stor itu ada 2 orang qadi syar'i, dan wilayah Jala ada 2 orang qadi syar'i. Di Betong, Betong ni satu daerah daripada Jala kerana dia jauh di antara Jala, Madinah ataupun kota Jala itu, bandar Jala dengan Betong itu agak jauhnya 140 km. Dia satu daerah daripada Jala, maka dilantik qadi syar'i 1 orang di situ. Jadi kesemuanya qadi syar'i di selatan Thailand, 4 wilayah ini, 9 orang qadi syar'i. Yang terdapat mereka menghukumkan syariah Islam berkaitan dengan keluarga dan juga pusaka warisan. Kalau kita tinjau kepada perkembangan undang-undang di Thailand, tidak dapat dipisahkan daripada konteks sejarah. Sejarah latar belakang negeri selatan Thailand itu namakan negeri Fatani pada zaman dahulu, berkaitan dengan budayanya yang berlainan dengan non-Muslim di Thailand, dan sosial negara ini didapati bahawasanya pengaruh undang-undang Islam ni dalam konteks wilayah selatan Thailand, iaitu 4 wilayah itu masuk 2 daerah daripada wilayah Songkhla. Undang-undang Islam diterima sebagai sistem perundangan alternatif dalam hal-hal tertentu. Terutamanya dalam kes-kes yang berkaitan dengan perkahwinan, perceraian, pusaka warisan dan juga hak asasi keluarga. Contohnya, dalam kes perkahwinan, dalam kes qadi syar'i, perkahwinan. Nah, yaitu sistem perundangan Islam. Nah, menuntut adanya kontrak nikah yang sah dan mengikut hukum syariah. Nah, dan juga nah, pembahagian harta. Nah, pembahagian harta begitu juga dalam hal warisan. Pembahagian harta dilakukan mengikut peraturan-peraturan yang ditetapkan dalam Al-Quranul Karim. Sebab mereka beramal dengan ayat-ayat Allah Subhanahu wa taala. Nah, dalam Al-Quranul Karim didapati bahawasanya undang-undang yang berkaitan dengan keluarga dan juga hukum syar'i mereka ambil daripada Al-Quranul Karim dan hadis Nabi SAW. Karena kalau kita tinjau kepada syariah Islam, terdapat banyak ayat-ayat Al-Quran dan juga hadis-hadis Nabi SAW yang membahas isu-isu berkaitan dengan undang-undang keluarga seperti perkahwinan, perceraian, hak-hak isteri dan juga penjagaan anak-anak serta hukum faraid yang berkenaan dengan pembahagian warisan. Yang pertama saya akan contoh daripada ayat Allah SWT Al-Quran Al-Karim yang berkaitan dengan perkahwinan. Allah Subhanahu wa taala berfirman, wa ankihul ayama minkum was-salihina min ibadikum wa imaikum in yakunu fuqara yughnihumullah min fadlih wallahu wasi'un alim. Allah Subhanahu wa taala berfirman yang bermaksudnya, dan kahwinkanlah orang-orang bujang, lelaki dan juga perempuan dari kalangan kamu, dan orang-orang yang salah dari hamba kamu, lelaki dan juga perempuan. Jika mereka miskin, Allah akan memberikan kekayaan kepada mereka dari limpah kurnia, kerana Allah SWT Maha Kuasa, Maha Luas. Allah SWT Maha Luas rahmatnya dan limpah kurnianya, lagi Maha mengetahui. Jadi ayat ini menyarankan agar umat Islam menikahkan orang yang bujang, baik lelaki maupun perempuan, wanita. Dan Allah berjanji akan memberikan rezeki kepada mereka. Kedua, yang berkaitan dengan perceraian. Allah SWT berfirman dalam Quranul Karim, at-talaqu marratan wa imsakum bima'rufin aw tasrihum bi ihsan. Yang bermaksudnya talak yang boleh dirajak kembali itu hanya 2 kali. Sesudah itu bolehlah ia rajak dan memegang terus istrinya itu dengan cara yang sepatutnya atau melepaskan, iaitu menceraikannya dengan cara yang baik. Ini ayat ini Allah SWT menjelaskan bahawa talak dibenarkan. Cerai itu dibenarkan 2 kali dengan syarat dilakukan dengan cara yang baik dan bermaruah. Jika tidak ada kemungkinan untuk rajak kembali, maka perceraian itu harus dilakukan dengan cara yang baik, iaitu bi-ihsan. Kemudian sebagai contoh yang 3 itu berkaitan dengan faraid atau warisan. Allah Subhanahu wa taala berfirman mengatakan yusikumullahu fi auladikum lidzakari mithlu hadzil unsayain. Yang bermaksudnya Allah perintahkan kamu mengenai pembahagian harta pusaka itu untuk anak-anak kamu, yaitu sebahagian yaitu seorang anak lelaki menyama bahagian 2 orang anak perempuan. Jadi ayat ini Allah SWT menerangkan bagaimanakah pembahagian warisan di kalangan lelaki dan perempuan, di mana seorang lelaki mendapat bahagian seperti 2 perempuan dalam warisannya, iaitu perempuan dapat setengah daripada lelaki, berarti lelaki dapat 2 bahagian, perempuan hanya dapat 1 bahagian. Ini mengikut hukuman yang dijalankan di selatan Thailand. Satu laginya wasiat. Allah SWT berfirman dalam Quranul Karim. Ayat berkaitan dengan wasiat. Kutiba alaikum idza hadar ahadakumul maut in taraka khairan wasiyatu lil walidaini wal aqrabina bil ma'ruf haqqan 'alal muttaqin. Yang bermaksudnya, kamu diwajibkan apabila seseorang dari kamu hampir mati jika ia ada meninggalkan harta, hendaklah ia membuat wasiat untuk ibu bapa dan kaum kerabat dengan cara yang baik menurut peraturan agama sebagai mana suatu kewajipan atas orang-orang yang bertakwa kepada Allah Subhanahu Wa Taala. Jadi ayat ini, Allah menceritakan keadaan permulaan dalam syariat Islam, iaitu menyuruh umat Islam untuk berwasiat mengenai harta mereka kepada ibu bapa dan kaum kerabat itu. Mengikut peraturan yang ditetapkan oleh syariat, pada akhirnya tidak dibenarkan wasiat kepada mereka yang sudah dapat pusaka daripada si mati. Mana itu yang berkaitan dengan hukum hakam Islam ataupun Islamic law. Dan juga hadis Nabi SAW berkaitan dengan undang-undang keluarga dan hukum faraid. Berikutnya adalah beberapa hadis yang berkaitan dengan undang-undang tersebut. Jadi, yang berkaitan dengan perkahwinan, Rasulullah SAW bersabda, "An-nikahu sunnati faman lam ya'mal bi sunnati falaysa minni." Atau lafaz yang lain kata, "Faman raghiba an sunnati falaysa minni." Yang bermaksudnya perkahwinan adalah sunnahku. Barang siapa yang tidak beramal dengan sunnahku, maka dia bukan dari golonganku. Jadi hadis ini menunjukkan bahawa perkahwinan adalah salah satu daripada sunnah Nabi SAW dan umat Islam digalakkan mengikut sunnah Rasulullah SAW tersebut. Yang kedua yang berkaitan dengan perceraian, Rasulullah SAW bersabda dalam satu hadis yang sahih mengatakan, walau ada pertikaian di antara ulama mengatakan sahih dan dhaif dan sebagainya, abghadul halal ilallah at-talaq, yang berkaitan, yang maksudnya perceraian adalah perkara yang paling dibenci oleh Allah SWT walaupun dibenarkan. Jadi hadis ini menunjukkan bahawa perceraian adalah perkara yang tidak sesuai atau tidak disukai oleh Allah SWT, namun ia tetap dibenarkan dalam keadaan tertentu. Kemudian pula sebagai contoh daripada hadis Nabi SAW dan berkaitan dengan faraid atau warisan, Rasulullah SAW bersabda, "Ittaqullaha fin nisa fa innakum akhadhtumuhunna bi amanatillah wastahlaltum furujahunna bi kalimatillah." Jadi yang bermaksudnya, bertakwalah kepada Allah Subhanahu Wa Taala dalam urusan wanita, kerana kalian mengambilnya dengan amanah Allah dan kalian menghalalkan farajnya dengan kalimah Allah Subhanahu Wa Taala. Jadi hadis ini mengingatkan umat Islam mengenai hak wanita dalam pembahagian warisan sebagai sebahagian daripada hak-hak mereka dalam keluarga dan mengarahkan mereka untuk menghormati hak wanita dalam undang-undang keluarga. Kemudian yang berkaitan dengan hadis berkaitan dengan wasiat, la wasiyata liwaris, yang bermaksudnya tiada wasiat untuk ahli waris. Jadi Nabi kita menjelaskan dalam hadis ini mengatakan tidak boleh ada wasiat yang diberikan kepada ahli waris yang sudah layak menerima warisan mereka mengikut hukum faraid. Mana pembahagian warisan hendaklah dilakukan sesuai dengan hukum yang telah ditentukan dalam syariat Islam. Dengan sebab ada hukuman-hukuman yang berkaitan dengan Islam yang disebut dalam Al-Quranul Karim dan juga dalam hadis Nabi kita Muhammad sallallahu alaihi wasallam. Jadi ayat-ayat Al-Quran dan hadis-hadis Nabi sallallahu alaihi wasallam yang berkaitan dengan undang-undang keluarga dan faraid memberikan asas perundangan yang lengkap untuk mengatur hubungan keluarga dan pembahagian warisan dalam syariat Islam. Hukum keluarga memberi tumpuan kepada hak-hak pasangan suami isteri. Penjagaan anak-anak dan pengurusan perceraian, sementara hukum faraid menjelaskan cara pembahagian harta warisan yang adil yang memastikan hak setiap individu dalam keluarga dilindungi. Sebab itulah tuntutan umat Islam di selatan Thailand ini minta rayuan kepada kerajaan Thai supaya mengesahkan bab 5 dan bab 6 hukum yang berkaitan dengan keluarga dan juga yang berkaitan dengan dengan warisan. Mereka luruskan, mereka izinkan. Dengan itu, kalau kita lihat kepada cabaran dalam penggunaan undang-undang Islam dalam sistem perundangan negara ni, jadi salah satu cabaran utama yang timbul daripada penerapan permohonan undang-undang Islam dalam wilayah ini adalah konflik antara undang-undang sivil dan undang-undang Islam. Jadi undang-undang Islam dalam sistem perundangan negara ni, dia salah satu cabaran utama yang timbul daripada penerapan undang-undang Islam dalam wilayah ini adalah konflik antara undang-undang sivil dan undang-undang Islam. Ini jelas berlaku apabila terdapat ketidaksesuaian antara undang-undang negara yang berasaskan sistem barat dan keperluan masyarakat Muslim setempat yang lebih cenderung kepada peraturan-peraturan yang terkandung dalam syariat Islam dan Al-Quran dan juga Sunnah. Isu-isu seperti peranan wanita dalam keluarga, hak penjagaan anak dan pembahagian harta warisan sering kali menjadi tidak mana satu titik pertembungan antara kedua-dua sistem undang-undang ini. Kalau jelas sekali konflik berlaku apabila terdapat ketidaksesuaian antara undang-undang negara dan yang berasas sistem barat dan keperluan masyarakat Muslim setempat yang lebih cenderung kepada peraturan yang terkandung dalam syariat Islam, iaitu Al-Quran dan juga Sunnah Nabi SAW. Isu-isu pertembungan, pertembungan di selatan Thailand ini seperti peranan wanita dalam keluarga, hak penjagaan anak dan pembahagian harta warisan sering kali menjadi titik pertembungan antara kedua sistem undang-undang ini. Jadi kalau kita tengok kesan kepada globalisasi, kesan pada globalisasi didapati bahawasanya selatan Thailand ini globalisasi turut memberi kesan terhadap perkembangan undang-undang di Thailand. Dengan adanya pergerakan bebas individu dan kepentingan ekonomi yang semakin mendunia, banyak peraturan dan amalan undang-undang di negara-negara lain yang turut memberi impak kepada sistem perundangan Thailand. Hal ini menyebabkan kerajaan Thailand perlu menyeimbangkan antara keperluan untuk mematuhi prinsip-prinsip perundangan antarabangsa daripada masa yang sama, menghormati tradisi dan nilai-nilai tempatan yang terdapat dalam masyarakat Muslim di wilayah selatan Thailand. Yang kita jadi kesimpulannya, pertama, sistem alternatif, yaitu perundangan Islam telah menjadi sistem alternatif yang diterima oleh masyarakat Muslim di wilayah tersebut, di mana ia lebih relevan dengan nilai-nilai agama dan juga budaya setempat. Yang kedua, peranan penting. Sistem perundangan Islam memainkan peranan penting dalam menyelesaikan kes-kes yang berkaitan dengan perkahwinan, perceraian, hak-hak isteri, penjagaan anak dan pembahagian warisan yang tidak hanya dilaksanakan oleh mahkamah sivil tetapi juga oleh Datuk Qadi Syar'i yang berperanan untuk memutuskan kes-kes mengikut prinsip syariah. Dan juga cabaran utama, kajian ini juga mendedahkan cabaran-cabaran utama dalam mengharmonikan kedua-dua sistem perundangan, iaitu sistem perundangan sivil yang berasaskan undang-undang barat dan undang-undang Islam yang berasaskan kepada prinsip Islam. Kemudian sebagai saranan untuk menangani ketegangan antara undang-undang sivil dan undang-undang Islam. Disarankan agar kerajaan Thailand memperkenalkan mekanisme penyelarasan yang lebih efektif antara kedua sistem tersebut. Dan juga penyelarasan memastikan bahawa mahkamah sivil dan mahkamah syariah dapat bekerjasama dalam menangani kes-kes yang melibatkan isu keluarga dan warisan. Dan juga perlindungan hak wanita dan kanak-kanak itu memastikan bahawa hak wanita dan kanak-kanak dilindungi sepenuhnya dalam kes-kes yang melibatkan undang-undang keluarga. Pendidikan dan juga latihan, memberikan pendidikan dan latihan yang lebih mendalam kepada para hakim dan mengamalkan undang-undang di wilayah selatan Thailand. Peranan masyarakat, penglibatan masyarakat tempatan dalam proses pembentukan undang-undang. Dapati bahawa pengaruh globalisasi, globalisasi yang semakin berkembang memerlukan Thailand untuk lebih sensitif dan lebih sensitif terhadap kesan perundangan antarabangsa. Dan juga pendekatan inklusif, pendekatan yang inklusif yang menghormati pelbagai sistem perundangan akan memastikan pembangunan lebih seimbang dan adil untuk semua lapisan masyarakat. Kemudian kalau kita nak lihat kepada sumber relevan, sumber-sumber yang relevan, jadi didapati yang kita boleh lihat untuk kajian ini termasuk ruang undang-undang Islam di Thailand oleh Abdul Hadi Usman dan perundangan Thailand asas dan praktik oleh Sirisak Tan Panit dan juga globalisasi dan perubahan sosial di Asia Tenggara oleh Mariani Uthman dan hukum syariah dan perundangan Thai, konflik dan juga sinergi oleh Muhammad Taufik. Itu penyampaian saya pada hari ini. Saya sebelum saya nak tamat ni, sedikit masa seminit, insya-Allah saya nak hadiahkan satu pantung daripada Universiti Fatani. Berikut adalah pantung yang menggambarkan kerjasama ataupun kasih mesra, hubungan dan juga kerjasama antara Fakultas Hukum Universitas Islam Bandung dan Fakultas Islam dan Undang-Undang Universiti Fatani. Bersama ilmu meniti jalan mulia. Fakultas Hukum dan Undang-Undang berpadu tenaga. Dari Bandung ke Fatani, erat hubungan terjalin. Kerjasama kukuh maju bersama demi kejayaan yang gemilang. Semoga hubungan dan kerjasama ini terus berkembang dan memberi manfaat, insya-Allah. Aqul qala hadza wa astaghfirullah li wa lakum wa afawwidu amri ila Allah innallaha basirun bil ibad. Wassallallahu ala nabiyyina Muhammad wa ala alihi wa sahbihi wasallam. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Please give him Professor Abdul Rahman big applause for us. Okay, there is very insightful and informative condition about the legal system works in Thailand, especially in southern part of Thailand, which is applied Islamic legal systems there. We know from the explanation there is still conflict between the Islamic legal system in Thailand, and there is a lot of challenge also with the civil law system in Thailand. Hopefully, this discussion will stimulate the engagement and the development in response to the globalization trends in the future, of course. Okay, now we move to the last but not least. The last speaker is from Germany, our Honorable Professor Dr. Stefan Kus from Universitas der Bundeswehr München. Prof. Kus, I'm sorry, you can hear my voice? Hello, Prof. Stefan Kus.
Sorry, yes, I can hear you.
Yeah, okay. We also hear you clearly. Are you ready, Prof. Kus?
Ya, tapi mohon maaf kalau slide tidak pindah, informasikan saya ya. Kadang-kadang dari sini slide di PowerPoint tidak pindah di Zoom ya. Kalau lihat tidak ada next slide, please inform me ya.
Yeah, of course. Okay, if you're ready, Prof. Stefan Kus, the stage and the floor is yours.
Yes, thank you very much. Good morning. Today, I would like to speak about, it's actually an overview about several topics which I work on at the moment in terms of cyber law. And I'm very interested, especially in the change for the systematics of the law and of the basis of the law, and not so much in the details. That's why I work on the impact of the AI and of several issues like the blockchain technology on the law. And my topic is the digital paradigm shift from human-centered to hybrid legal architecture. I would like to show you that in the future, and this is not so far away, we might have a change in the role of the law. You find that already in research of mine 2 years ago about the digital globalization of the law, which in my opinion leads to a diminishing of the meaning of the law and of the purpose of the law due to a diminishing of the role of trust and humanism in the society. So we will have a replacement of the law by technology. And I would like to show you something about that. So I would like to talk about some aspects of that. The first and maybe the most important aspect, which I always tell my students, is the data. I mean, Indonesia has a system in university, ada mata kuliah data protection, perlindungan data pribadi, ada perlindungan konsumen, ada hukum persaingan usaha. Yeah, we all have that all, and this is all separate from each other. But the most important for my students when we talk about the influence of digitalization and of the digital law is, in my opinion, that they should see the law in a more comprehensive way, and let's say the element which is fitting it together is the data. Yeah, so we cannot see this all separate from each other. We cannot see consumer protection without data protection. We cannot see unfair competition without consumer protection and data protection. With other words, the data actually are the element for everything. The data are important for the monopolization of the platforms and therefore for the power of companies. So competition law is not understandable nowadays without data. And the most important aspect of that is that data are ambivalent. It means that on one side, we talk, and that is the more conservative way to teach data protection law, we talk about the protection of the privacy. However, the protection of the privacy is only one and not the most important aspect nowadays, because the protection of the privacy is a very conservative and traditional way to understand the data. However, we must see that the data nowadays are also used as a power instrument, and also therefore, as a power instrument, you can close markets with data. That means we must open data maybe to competitors. And that again means a conflict with the privacy. So Nowadays, we must think about how to limit the privacy aspect of the data, or how to equilibrate the privacy aspect of the data with market aspects, with innovation aspects. If we understand data protection in the conservative way as we always did it, for example, we will close down innovation. Yeah, we could see that very good in the pandemic when I was actually not allowed to use any Zoom for my lecturing, because Zoom has servers in the United States and we cannot transfer data to United States, so also not of the login data of my students, but I had to do it nevertheless. Yeah, so I would have to stop my work if I did not use this. So this is what I mean with the ambivalent role of the data. The data is the central element of all. Control over data is key to market dominance, and market access to data must be ensured to prevent monopolies, and that's a conflict with the privacy. So we need to rethink the role of the data protection. We must go away, in my opinion, from a too strong prohibitive data protection to a more open concept, which is protecting privacy on the same hand as it is opening data for opening markets and for fostering innovation. And that is also applying to copyright law, as I will explain later. The next aspect is that we always talk very conservative about the monopolistic large language models as we talk about the monopolistic platforms. The large language models indeed are very hard to copy, like ChatGPT or Claude or Grok or whatever the name is. They're hard to copy because they are trained on a big amount and a vast amount of data, of course. And it is very expensive to train them in so that we can keep step with these platforms. However, we must understand, and that's also to understand for understanding the AI generally, that these large language models are not innovative. They are not innovative because the system or the principle of the machine learning, which is applied here, is nothing new. It is coming from the 60s, as I know. However, what is new is that we have the big capacity for storing data nowadays, and we have a big capacity for computing, which we did not have in the 60s, in the 70s, in the 80s, and in the 90s, and in the 2000s. We have it now. That means we can store this immense amount of data to train the systems, and that makes the large language systems models practicable and usable, and that's why we think, and it seems to us that we have a revolution in the AI. We have a revolution, but not due to the principle. We have a revolution due to the capacities, the technical capacities for storing data. So that means, yeah, of course, these systems are growing with the amount of data and the amount of the capacity of computing centers and so on, and that is very expensive, and it is hard to copy. However, it is possible that in the future, this monopolistic aspect is not so important anymore, as large language models might become commodity. It means that actually the interesting part of the value of the production of value will not be in the large language models, but will be in high specialized small AI models, which are set up on these large language models. With other words, it is possible that these quasi-monopolistic large language models will be understandable as commodity, and will be also opened by regulations worldwide with extraterritorial effects in order to open the platforms for high specialized small AI models. That is a big chance for countries like Indonesia, or also for Germany or for European Union, as we don't have the big large language models, but we can develop in the medical technology, in the law tech, everywhere. We can develop smaller models which are set up on the big large language models without having to collect these large amounts of data, but with high specialized specialized specific models which make the value in the end of the day. Same as the oil is not so important, but maybe more important is what you produce from the oil. The next aspect is very important, is the safety by design. I mentioned already protection aspect like the data protection, the privacy protection, and of course, we will have a big threat, and we have already a big threat with the big platforms like the Meta platform or Google or whatever. These platforms collect data. These platforms might infringe rights of people all over the world, and when we talk about the large language models, we all know the danger of the AI, that the AI can hallucinate, the AI can maybe influence elections, and so on and so on. And the question is how we protect ourselves from that. So my thesis is that before we talk about prohibitively regulating something and kill all innovation, especially in our countries, because regulation usually is hitting our own companies. So the AI regulation in European Union is maybe hitting more our own companies like as the big platforms. We need to think about rules for safety by design. It means that the safety and the diminishing of the danger of the platform should be already proactively by safety measures in the integrating before the product is placed in the market. So we need to force the companies to integrate safety measurements into the product, into the platforms before it comes to the market. And then we need to have rules, and that is at least in parts already in the AI regulation, maybe not optimal, but already it starts, and we have it especially in our data protection regulation in the European Union. We need accountability, we need ensuring compliance with safety rules throughout the whole product life cycle, which is bringing, of course, the duty of the platform owners to observe their product permanently. So the law requires safety features in higher risk sectors. So we have to measure the risk level. However, that is problematic maybe because it makes a lot of accountability duties, a lot of documentation duties, and it is possible that companies later on hide behind these documentation duties. Yeah. However, there is no other way than to force companies to make the product safe before it comes to the market. And here is a loophole in the Indonesian data protection law, as the Indonesian data protection law, as you know, is copying a lot of the European data protection regulation. However, exactly the safety by design rule in Article 25 of the GDPR is not integrated into the data protection law of Indonesia, which maybe pose a problem in the future. And when we talk about dark patterns powered by AI and so on. So that cannot be handled by the Indonesian data protection law, not yet. I have no idea why they did not integrate it. A next aspect is very important. I think here is the real disruption in the law. We didn't have so far disruptions in the law by technology. We did not have, for example, disruption with the internet. The internet was also speeding up the communication, but it did not change the principles of the law, especially in the civil law. It did not change anything when we talk about the contract law. Contracts are contracts as it is in the internet or is it before the internet. It's just more fast. It is just with the different instruments. However, here we have a real disruptive impact. Behavioral legal concepts come to their limit. I mean with that our legal concepts, of course, are based on human behavior, on a humanistic background. When we talk about contracts, we talk about intent, contractual intent. We talk about private autonomy. We talk about contractual freedom aspects, privacy aspects, freedom aspect, private autonomy are based on constitutional and, in the end, legal philosophical concepts of freedom, of the freedom of the individual. The freedom of the individual is needing an instrument in the private law, for example, for the freedom in the law system. And we need for that, we need the private autonomy. We need the freedom to make contracts free based on contractual intent. However, if we talk in the future about AI agents, or better said, not agents, better said, independent AI systems, contracting independently of human beings, bots which make contracts which are assigned later to human or to companies, then we cannot talk about legal intent. We cannot talk about contractual intent anymore. So if we really want algorithmic contracting, we cannot do that on the basis of the behavioral contract law. We need to think about analogy. Analogy is problematic because we need then to leave the legal philosophy and the philosophical and the contractual basis of the private law, of the contract law, or we need to talk about algorithmic contract law sui generis of its own art, of its own kind, yeah, because then we have a chance to not leave our philosophical basis of the law and have some machine law. And that is interesting. That would be a real cyber law. That would be a real machine law. We would have a separate law for machines in order to protect our humanistic basis of the contract law. And the same applies to other aspects like liability, for example, or about the competition law, for example. In the competition law, we talk about anti-competitive behavior. Anti-competitive behavior, but what if algorithms influence markets? Algorithms influence markets without any influence of a human being. Means we don't have just an agent which have some rules by humans and is actually in the end of the day conducted by human, but we talk about absolutely independent bots in the markets which influence the market, and that is not possible to seize that, to grab that with our traditional competition law, because the competition law is based on behavior. It's a behavioral aspect. Same applies to liability. Liability in liability, we talk about guilt. Yeah, we talk about responsibility. I will come to that later. We talk about responsibility. How can a machine be responsible? The responsibility factor is not there anymore. So this means as the AI operates differently, there is no intent, there is no emotion, there is moral understanding. I just some month ago read an Indonesian article about can AI be criminal, and then talking about options for making AI criminal. This is absolutely nonsense. However, of course you can discuss it, but it's so far nonsense, because to be a criminal, you need a moral understanding about what you do. So how you can be a criminal if you have if you have a deterministic understanding? So this is absolutely not applicable to AI. So algorithmic decisions challenge the concept of accountability. Assigning liability without human intent is difficult. We need different concepts for that. In the beginning, we'll be able to work with concepts like AI as agent. When the Australian Supreme Court talked about AI as inventor, it did not mean AI can be the owner of the patent, but it can be the inventor acting like an agent, which means that the invention done by the AI is assigned to the human being using the AI as an agent. Yeah. So there we have some link to the human being in the end of the day, and then we can assign, of course, responsibilities and also profits to the human being behind the AI. But if the AI is absolutely independent in the future, that is not possible anymore. The next aspect, very, very, very important, to shift from individual to organizational liability. In my opinion, here is, I mentioned that in the slide before already, here is a very important aspect, because we have more and more organizations, instruments, systems, which are so complicated that nobody can oversee anymore the risks. And therefore, it is hard to minimize the risks by individuals. This is not only applying to digital law. It's also applying to the company law or the law of associations. If we have a complicated concern structure or a complicated company, a complicated international global acting company, or we have a supply chain, international supply chain, European Union has a supply chain due diligence law, and in the supply chain due diligence, we must assign responsibilities for human rights infringements somewhere in their supply chain, and the European Union supply chain due diligence law assigns responsibility in the whole supply chain for a company. So if there is a European company having a supply chain of 5, 6, 7 suppliers, and the last one is the producer of tin mining in Bangka, then there is responsibility for human rights infringement. So if something happens within the supply chain, how we can assign responsibilities here? We can, of course, not force a company to be responsible for each human rights infringement done by an individual somewhere in the supply chain. It needs to regulate observation duties, organization duties, to organize, to make sure the supply chain can be overseen as best as possible, but of course, in a reasonable way that it is realistic. So organizational liability means here that the supply chain needs mechanism to observe what happens within the supply chain, even if it's in the supply chain far behind. And that also applies to other organisms like organizations, like companies, but also in AI. As we know, some people say, why we don't make the developers of the AI responsible for infringements or for damages the AI makes when it is used in some markets. Is that really realistic? Yes. Can we really say, okay, the trainer of the AI, for example, training the AI model with copyrighted works, is responsible for every copyright infringement which is done by some user in the end in the market where the AI is used? Can we really do that? Can we really say that? And the answer is no. Actually, when we have an AI, I saw a very nice picture about what is AI, and you saw this banda, yeah, you saw this rope going, and there is input, and it make like this, and then comes out, and then is output. It means we have a black box. Even if we say, okay, we use this data for the training of the AI, it doesn't mean that we can say what the AI will do out of that. Yeah. So in the end, there comes a product which is maybe having something from the input, but we cannot say how it did it. There is a black box. So even the producers cannot say how the AI is making the output out of the input. This means it is not possible. It is not possible to be responsible for every output coming out of the AI. And that is a problem for organizational liability. That means we need to find mechanisms for diffuse responsibility, so complex processes that spread accountability across organizations or in complicated systems. We need internal controls to prevent illegal activities. We need a growing role of accreditation agencies and certification agencies. There will be a big role of proving that the developers did all best and all necessary and all possible to avoid problems, and that they observe their model, and in case of problem or danger, call back the model and modify their model in a proper way. And that is, in my opinion, the future. So we will have more and more a shift from this individual liability to this organizational liability. And as I mentioned, the growing role of accreditation agencies and certification agencies in the future. However, this is also a problem a little bit because it might lead to the situation that nobody is really responsible anymore, and that we have more and more a flood of certifications, a flood of documentations, and companies might hide behind these documentations, and the problem is maybe not solved. Self-responsibility in the legal framework is paramount, is the most important. We will not be able to protect the citizens anymore properly. We will not be able, with data protection law, to protect individuals properly against the threats of the platforms, of the global acting platforms. Individual responsibility is growing, so the individual must manage their own data protection. That's why I say the prohibitive aspect is coming to the limit. The prohibitive aspect is a problem for innovation. The prohibitive aspect should be modified with a more open aspect, shifting more to personal responsibility, we need more digital literacy, so we need to shift for training the citizen to be more aware of the threats for their data, for their privacy. We need more pragmatical regulation approach because, as I said, the protection purpose of for example, of the data protection law, but also of the AI regulation is very limited because our territorial power is limited. We have not the sovereignty anymore to regulate international global acting platforms effectively with our national legislation. So if Indonesia is regulating something, there is a chance that this regulation is not respected by global acting US platforms. European Union can, in a certain amount, doing this because we need our market, so we have a certain extraterritorial power here. This is also, I mentioned that in the other place already, this is a shift from international law to political power principles, so the law of the strongest will win. However, we must face the fact that we will not be able to protect our citizens effectively against the international platforms. This means if we have ineffective law, which is limiting our innovation power, we need to think about new concepts. And the new concept would be more pragmatical regulation. In the data protection, for example, we can say that the Homo digitalis is not so keen on this strict protection anymore. I mean, people share everything in platforms anyway. So the Homo digitalis is not awaiting that he is not observed. This means we have also the social reality, which has changed since the 80s or 90s of the 20th century to a more open approach of the people of the society with sharing data. So it means we should rethink from this too strict prohibitive aspect to a more pragmatic aspect, and this is also important for the AI. AI, creativity and culture, fundamental cultural challenge in the fusion of human and algorithmic creativity. I say to my students often, we are already cyborgs. We are already creative cyborgs. We already add to our own creativity the AI. So what I mean with that is, if we see how AI is producing something, that we can feed AI with data or with texts from other people, and then we let it produce new text, or we can make fan literature by feeding it with all the books of Harry Potter, for example, and then tell the AI, make me a sequel of Harry Potter in the style of the author of Harry Potter. Then we see where it comes to. Yeah, so what is it worth to be creative in the future if the AI can produce works so easy and so fast, and any idiot can write everything about everything, even if he has no idea, or everyone can make art? Some people in Germany say, I read an article about that is democratization of creative production and of art, because you don't need skills anymore to be creative. You don't need skills anymore to produce something. You can do it. Everyone can do it without skills. Isn't that democratization? I think there is a certain chance for a cultural erosion, because mass algorithmic production will devaluate the value of the culture and of the art and of the literature, and there's a risk of devaluing cultural good. However, there is maybe a chance for a retrocultural reaction, same as we see that people like vinyl when they hear music, same as we see that people like mechanical watches and pay a big amount of money for mechanical watch, even if an Apple Watch is more accurate or a cheap quartz watch is more accurate, it seems that people have the tendency to be bored by fast, achievable products, or by products which are too comfortable. And it can be that the people are bored. I mean, people are already bored. You see my presentation here. My presentation is not containing any picture of AI, any illustration of AI, which I did in the beginning, because nobody is wondering anymore. Anyone is bored about all these AI pictures. When I see AI picture in LinkedIn, I already scroll. And that means we might come back to a more conservative approach in culture again, and the future might be a hybrid culture. And that means we might have editorials, for example, who guarantee us provable that the books they issue, they edit, are done by human author without the use of AI. We will pay a lot of money for that because of course, these skilled authors will be high paid. That means we will have luxury cultural products which are not created by AI, which are more expensive, which are used by rich people, and we will have a renaissance of the classic. People will read the Lord of the Rings. They will love it because they can be sure it's coming from a time where the AI did not produce it. So people will use and will read the traditional art and will pay a lot of money for the old art, for the retro cultural art, for the old products, for the real human products. And that, again, is a big role for the accreditation companies, for the certification companies, and the future might be hybrid.
Prof. Stefan Kus, I'm sorry to interrupt you.
We will not get rid of that. Let me just finish my sentence. We will not get rid of the AI art. We will not get rid of the AI, and we will not get rid of a sort of replacing, but we will maybe not lose all of our old culture. And that's what I mean with hybrid, and that's what I mean with we are already sort of cyborgs, because we will integrate it in a certain way in our thinking, in our producing, in our creativity. However,
Stefan Kus,
take care that we did not that we do not lose all.
sorry to interrupt you, Prof.
That you
Stefan
let me
Kus.
finish my sentence. Thank you so much.
Okay. Give applause for Prof. Stefan Kus, ladies and gentlemen. Thank you for your insightful presentation, Prof. Stefan Kus. Right now, we are going to the session of discussion and Q&A session. Okay. I just want to stipulate the regulation here about the Q&A sessions. First, we only can allocate 3% to posing or asking the questions. Okay, just 3%, and you are freely to asking from any other or each presenter or speaker. There is any question or discussion from inside here? Okay, the one, the back, yeah, one, and the second participant, yeah, one. Maybe I have to give the chance, opportunity to the participant in Zoom. Is there any or one participant in Zoom want to posing the question to the speaker? The operator, would you mind to help me? If there are participants who want to ask question in Zoom. Okay, maybe we have to start here inside participant. You can answer and posing questions to the presenter. Just one question. Okay, please mention your name and your institution.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
First of all, let me say barakallahu fi umrik to my professor, Prof. Toto. I am Nino from Faculty of Medicine Unisba. This question is for Prof. Steven. In the AI era, can legal codification be done with AI? Has anyone implemented it yet? Is this possible with the nature of AI itself, which does not involve emotion and morals? What do you think, Prof. Stephen? Thank you.
Yeah, thank you very much. Yeah, there is already regulation on that, and in the EU we have a AI regulation. However, I'm not so sure what you mean with the emotionlessness. If you mean regulate the acting of the AI parallel to the acting of humans, that is not so easy. Yeah. So when we talk about liability, we still talk about liability of humans. Yeah. So if someone applies use AI for doing something or for producing something or for committing crimes, that is still must be still assigned to a human. And that might be in the future a problem, because as I mentioned, we have the problem of the liability and of the responsibility, because people will start to say it's not me, it's the AI doing that. I could not foresee what happened. Yeah, so it already starts with that. So in the competition law, we already have an issue in Germany that a company said we did not influence the pricing, we did not influence the market. The AI was observing the market, and the AI algorithm was raising the price. So collusion. And can you really talk about collusion if AIs observe each other, right? This is not possible, and AI is, of course, and cannot be a legal person, not at least not with that, because legal person we need some humanistic concept behind it. But regulation, yes, we have that, but I doubt it will be. It is really achieving what we want with that. For example, the AI regulation in the European Union is highly criticized because it poses transaction costs for developers, which are mostly hitting European small and big company and small and middle companies. Yeah, because the big platforms, they have the money for all these accountability things and for all these documentation issues. Yeah, which makes it very, very expensive to comply with the rules. But the small companies, the newcomers, they don't have that, and that means we are discriminating our own companies, and we give a chance more to be more strong for the big American platforms, which have the manpower for do this, right? And also the question is it really effective on the long term? As I mentioned, we have a digital globalization, and that means we have ubiquity, not territoriality. Ubiquity means or a state is regulating something, forbidding something, and then it forbids it for the whole world because it's in the internet. You cannot say it's only forbidden in Germany. You forbid something in a platform, and that is not taking place in the whole world anymore, right? So we don't have actually the competence as a nation to forbid something for the whole world, because we have sovereignty for our territory. And the other world, on the other side, if we're not doing this, if we're not acting extraterritorial, for what is our regulation worth it? Because if we're not doing it, then we cannot protect our citizens, because our regulation in our territory is not enough. Because you must stop this act in the platform, or you can stop the threat, right? So if we talk about data protection in Indonesia, if Indonesia wants to have data protection, then you must forbid some issue which is dangerous for the data and for the privacy of your citizen. And that means in a platform like Meta, it must happening in all the world. So the question is, will they really respect our data protection law or not? And that's my opinion why maybe Indonesia was copying big part of the European data protection regulation, because there is already a standard which has a chance maybe to enforce worldwide. Yeah. So my answer is, yeah, there is regulation, but the question is, how effective will this regulation be? We need equilibrium between innovation. You come from medical faculty, from medicine faculty, so AI will play a big useful role in the medicine. Yeah, if we stop it and we are too prohibitive in order to follow antique, old, traditional concept of legislation, which are based on territorial issues, like in the old time, in the old law, then we will kill the innovation because before we can come up to it. Yeah, so we need this equilibrium, and that is the most difficult part of the legislation in the future. And for Indonesia has a chance because Indonesia did not yet start it. So Indonesia should really observe clearly and should really critically think what is really realistically enforceable due to this digital globalization. I think that's enough. Thank you very much for your question.
Okay, thank you for the answer, Prof. Stephen Kos. Very comprehensive and holistic answer. And we move to the second participant questions. Is there, raise your hand? Yeah. Please mention your name and your institution. Okay.
Hello, my name is Riza from the Faculty of Communication. I just want to know, Professor Stefan, you said that privacy is really important, just like how I think too. But in Indonesia, people in business, marketing, and all of that in every platform seems to have their privacy breached by every people in the world. And some theorize even by the government. So people tend to just give up and be apathetic towards it and just ignore the fact that they have their information being taken without consent. Now that makes me think about how do we make people aware of this situation, because people are just too ignorant. Now my only solution to this topic is just to make people aware of this situation, but how do we do that exactly? Thank you.
This is an excellent question, because that is what I mean with the limits, of with the responsibility, and we see it not only in the data protection, also in the consumer protection. If I ask my students in Indonesia, are you feeling well protected by consumer protection law in Indonesia? If you see the law number 8, 1999, it's quite modern. However, they all answer no. And if I see what all the time I get in my WhatsApp, advertising here, advertising there, I did not allow that. Then we see this law is not really effectively enforced. So this is we don't have to think about who is the responsibility. Maybe it's not conformed with the culture. So sometimes. So the people are maybe more anyway, the people is resignating. That is very true what you say, and that is this is a systematic problem, because it's a problem for the legislation, because it means that we have an erosion of the trust in the law. And if we have an erosion in the trust in the law, then we have erosion of the whole system, and that is to avoid. That's why I say go away from prohibitive concepts, which are anyway not enforceable in the global aspect, in this ubiquity aspect, because it leads to more erosion of the law, and then nobody will trust the law anymore. But it is important that people trust the law, because erosion in the law and erosion in the trust in the law leads to non-compliance of the citizens also in other aspects of the social life. And that's why I think we need consistent law, which is realistically enforceable. Now we come to your question. That means away from this prohibitive aspect, that the state can protect us against all the threats of the world, and so which is anyway not realistic, and go to more self-responsibility. So first of all, we must define what is the homo digitalis. You say people are irresponsible or something like that. That is very true. Look the Meta or look the Instagram. The people post their dead grandma in the coffins. The people post their children. We have Indonesian friends who post every step of their little children in Instagram, actually knowing that with AI you can just take parts of that picture or that movies and put it into children pornography. AI produced children pornography. Germany, the German police was seizing children pornography already made synthetically by AI, putting the faces of real children into this pornography, right? So don't post your children. People just don't know it, but they are irresponsible by this, So because there is the will of, I want to be public, I want to be a celebrity, And on the other side, I can also make money, because you can make a home story. I mean, I have an Indonesian wife, and we have 2 small children, very cute children. I could go to YouTube and make every day a home story. I could make a lot of money. I know Indonesian couple in Germany bought a house in Germany for almost 1 million, because they all the time post their family life, right? But I don't do it because I'm responsible. So what can we do? We cannot protect the people with the prohibitive law anymore. That is over. We must make the Homo digitalis more responsible. We must define what is the wish of the people, what is socially acceptable. Socially acceptable is more publicity for the people than before. In the 80s, the people were upset because of the state making some survey about to know what is the structure of the society. People were upset going to constitutional court. Nobody would do that nowadays anymore because nobody is surprised. Yeah, I'm also resigning. Yeah, so okay, they have my data. Yeah, of course. I mean, Instagram, you think I get my account for free? No, I pay with data. That is the concept of the European Union. We pay with data. Yeah. So the data is a payment function. So if it's a payment, who cares? Yeah. So we need to understand that it should not be so strict anymore because the society will tolerate and tolerates more, and that is actually okay. That is the time nowadays. And then there is the purpose of universities, for example, of the community services. For just an example, one of the examples, the community services could go to the villages and could train the people about that instead of just making some presentation about things the people just to give the presentation and then go again. Send people like you from communication science and tell the people living and seizable and understandable what is happening here. Because the Indonesia is a very heterogeneous society. There is urban society, which is not different than in Paris or Berlin or New York or wherever. And then there is the rural society where the Ibu and the Bapa just don't know. Yeah, so they go to Umrah and they don't know to close the door of the toilet because they have no idea about this. They're not stupid, but they are not educated in that. And that is the purpose of universities also. This is just an example. And we must train ourselves. We must become Homo digitalis. You in communication science, you will be like this, but not all. And I do that with my students. I tell my students, you cannot await that you are protected anymore by the law. And don't come with me to the internationalization of the law and we need international standards. And so that will not happen. Already Mr. Trump is changing everything. And already his future vice president says, we will exit NATO if European Union regulates Twitter. I mean, that will not work anymore. We will not have a consent internationally about protection standards. And the protection will not take place. It's your purpose. Thank you.
Thank you so much.
Okay, thank you, Prof. Dr. Stefan Kos, for the answer. But I have to inform you, I am informed by the committee organization that due to time constraint, I'm really sorry I have to close this session because our time is already out. So, at the end of the session, at the end of the seminar, I really appreciate, of course, to all of the speakers who have been given their material presentation, very insightful and very fruitful for us here to learn something new. Give applause for all of the speakers, please. And of course, thank you for all the participants who joined us starting from 8 a.m. until now, virtually or in Aula Utama Unisba right now. Thank you so much for your time and your attention. Hopefully this is gonna be insight for us and will stimulate the future research. Yeah. So I hope we can collaborate between Indonesia, Malaysia, and Thailand, and of course, Germany. So we can make the globalization as a positive impact for our respective countries. Thank you for your attention. I'm Rimba Supriyana, sign out. Thank you once again. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you to Mr. Rimba Supriyatna SHMH for the spectacular moderating of our discussion and Q&A session. Next, we will have the submission of certificate session. This session will be presenting the certificates to our distinguished speakers. The certificates will be given by the first Vice Rector of Unisba and fourth Vice Rector of Unisba. For the documentation team, please coordinate this session, and we kindly invite all our esteemed speakers to come forward to the stage. Also, we would like to invite the first Vice Rector of Unisba and the fourth Vice Rector of Unisba to present the certificates to our distinguished speakers. We welcome them to the stage.
Next, this session will be presenting the certificates to online distinguished speakers. The first one for Professor Dr. Stefan Kos, the second one for Professor Dr. Nur Asiah Muhammad, and the last one for Professor Dr. Abdurrahman Shapakia. For the documentation team, please coordinate this session. Following this, we will proceed with the group photo session, which will be guided by the documentation team. We kindly request all online participants to please enable their video. Thank you to the documentation team for guiding this session. Time passed by. Now we have reached the end of our event. We would like to thank all our esteemed guests for gracing us with their presence, both in offline and online participants. Our sincere gratitude goes out to the organizing committee for their meticulous planning and execution.
As the host, we humbly apologize for any mistakes or oversights that may have occurred. We acknowledge that we as humans are prone to making errors and that only God is perfect. Thank you for your patience and understanding.
Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much.
Buat tamu undangan tolong.
Silakan
Bahasa Inggris apa?
silakan kepada
Ya. Iya.
kamu persilahkan.
Iya.
Terus apa?
Itu pokoknya nyuruh makan.
Nggak kedengeran Pak, nggak kedengeran. Kami persilahkan tamu yang undangan untuk menikmati makanan yang sudah dihidangkan.
Thank you.
Mohon izin keluar.
Sertifikatnya ke email ya.